May I have your lordship's leave to mention one matter for listing as application, my lord? Grateful.
Matter. May I be permitted to mention one matter for listing?
What is it?
An application filed challenging an order dated 28.
Group 6.
My lord, may I be permitted to mention about inclusion? My lord, correction is there. My lord, so many matters that one to be mentioned.
My lord, to be mentioned, my lord.
May I have your lordship's kind leave to mention two writs your lordship will remember on the last day your lordship had restored one of the writs. I had submitted before your lordship that there is another writ which can be heard analogously and had been filed on subsequent facts. Lordship had directed me to mention on this day so that both the writs can be tagged and can...
What's the number?
I'll hand over this mentioning notice. Your lordship has both the numbers.
Okay.
I have only one more indulgence if I can seek your lordship. On the day that the matter was restored, your lordship was kind enough to place the matter on the 30th for orders, I believe. We haven't got a copy of the order that your lordship has passed. We are praying for an indulgence if the matter can be taken up 31st. We had a little difficulty tomorrow. Both the matters.
Yes. What else do you have?
May I be?
You are with him.
I am for the Air India lordship. Yes.
They are appearing as the respondent. Great. Great.
May I be allowed to mention a matter, your ladyship? This matter was, your ladyship was
What
pleased.
do you want? Just give whether
I
you
need
want an
to-
inclusion or not.
Your ladyship, I need to file a written notes of argument. Your ladyship was pleased to reserve the judgment in a matter. This is. I tender my apologies for the delay, your ladyship. If you kindly.
You were supposed to file it on an earlier date, which you didn't.
Yes, your ladyship.
Next. Phone record আছে তুলে দিন।
My lord, my apologies, my pertinent to mention one matter, my lord, for correction of order, my lord. My lord.
Number 1, my lord, I am for the petitioner, my lord.
Or I am for the CST led by Mr. Singh, my lord.
But this is a restoration application, my lord. We have served within limit, my lord, restoration file. Matter is come before your lordship as a old matter, my lord, dismissed it. New advocate on record, my lord, he is present, my lord. And my lord, we have filed the restoration within time. This is affidavit of service. And due to, my lord, ill health of the advocate, my lord, we are taking point that paragraph number 4 and 5.
So I have been hearing this for past few days. It's an old matter. So as if the old matters get listed, sir,
Yes,
it's a problem. If the old matters
No,
get
my lord. I just mentioned.
listed, so everybody comes and says
No, my lord.
it is an old matter. So the old matters
No, my
will
lord.
remain as it is.
My lord, I am
Nobody mentions
My lord,
the
also-
court on its own instance lists
We are
this
so much
matters.
fortunate, my lord, that the court was on to come. But my lord, he has failed to check the matter, my lord. Or the earlier advocate. The
Yes, which paragraph?
paragraph 4 and 5, my lord.
What is her name? Shormishta Poddar.
Yes, ma'am.
So today she will be there. After restoration, she won't be there. Neither she will be there. I can't say about you because you generally appear regularly. If not, it is extremely inconvenient for you. But I do find you regular. But I'm a
But
bit
I
apprehensive.
will appear, ma'am.
Okay.
আপনাকে দিয়েছিল কপি পাঠিয়ে আরেকটা জেরক্স করে দিয়ে দিন একটা করে দিন রেস্টোরেশন এখন দেখুন না
You said she has filed a fresh wakalatnama?
Yes, ma'am. In the department, ma'am.
When did she file?
11th April, ma'am. Petitioner and Vokalatama both filed.
11th April 2025.
Yes.
Now what you have written? Her name is Shormishta Poddar.
Yes.
So if she has filed the wakalatnama on 11th of April,
My
in
lord,
paragraph number
but
4, you have
there-
written
there
on
is-
7/3/2025,
ma'am.
learned advocate on record, Ms. Shormishta Poddar was suffering from
My lord.
fever.
My lord, I checked that matter, my lord. First, he filed, my lord, but it is filed by the one of the petitioner. They returned it. The Vokalatama returned by the department, then he again filed, so it is reflected as 11th of April. Because the original petitioner
Then
died.
what was the original date on which she had filed the wakalatnama?
That, my lord, that is not shown in the, my lord, department.
Then you have to change this paragraph, sir. It's contradictory.
My lord,
On 7th of March 2025,
yes, yes, ma'am.
she was not on record.
She is,
She was not on record, but you have
filed, but
stated
it is returned, my lord. My lord,
whatever it is, she
we
was
are
not
changed,
on
we
record.
changed.
Whatever you feel like you write, sir. Just see what you've written in the next paragraph, paragraph 5.
My lord.
The learned advocate representing the petitioner submitted that the advocate on record had filed the fresh wakalatnama on 11th of April,
Yes.
2025.
He filed earlier, but it's
The
not.
averments in paragraph 4 in CAN application being 2 of 2025 is contradictory to the submission of learned advocate representing the petitioner, who seeks to not press the application and file a fresh application, and the same is allowed. Affidavit of service filed by the learned advocate representing the petitioner be kept on record. How long will you take to file the
7 days, my lord. We do it.
next date be fixed on 8th of August
Ma'am.
for filing a fresh
Fresh.
application for restoration?
Ma'am.
Next.
I am for the insurance company. Mr. Bonik is the applicant.
Where is Mr. Bonik?
Well, he is told me that he is in the jam. He is okay. Thought person.
Next.
For announcement of the award, Mr. Kundu appears for the insurance company. Mr. Aurobindo Kundu. Probably he will come today.
He's not there today.
Let him be not today, but I send for him. Let him not today. He will come today.
The learned advocate representing the. Now I will not accept your mentioning in this, if this be the case, sir. You people will mention, thereafter it will be listed, and then nobody regularly turns up.
Notice have served. You appeared earlier question.
When did you serve?
I served. You appeared also with earlier question, my lord. Delay condone in 15th of January 2023. He appeared.
The learned advocate representing the appellant claimant is present. None appear to represent the respondent insurance company. Let the matter be adjourned for the day. If tomorrow he doesn't come, then I'll send administrative
Fine.
notice. Hey, this is the way everybody has to be forced to court. Next. Key correction ajete.
What?
Typographical error. Next.
Well, in this case, I am happy paper book has been filed, my lord. LCR has come. My lord, this is a ready for hearing. This is a case death of a my lord, injured person, 90% disability, expired in during pendency of the appeal. Substitution has been made, my lord.
Why have you filed the appeal, sir?
No, appeal, sir.
Why have you are the appellant?
Yes, yes.
I have paper.
My lord,
Yes.
your lordship, fixed it any day. Fixed it at forwards any day.
I asked you, sir, why did you file?
My lord, I am, my lord, assisting your lordship. My lord, they raised the question. There is a contributing negligence, though there is no such contributing negligence because of the fact, my lord, the FIR charge sheet and eyewitness has proved this. My lord, fact,
Heard
on
the
the ground
submission of
the
learned advocates representing both the parties. Let the matter be fixed on, I believe, August and September are full with orders.
August.
No. When will you get the date? Just see. They could not type out so many judgments. 23rd of September. None appeared. Sir, it's Mr. Bonix. And you are appearing for the insurance company.
Mr. Gopa Das.
My lord, Krishna Bonix appeal, my lord. They were to serve the paper book today, my lord.
Next, I'll give him some time. Next.
Lord, it was the matter has been disposed of, and after that, lordship, I have filed one application for lordship attaining majority. Only to that extent, can I allow my application for attaining majority, applicant number 1 and 2.
When did the applicant attain majority?
Yes, they have attained majority prior to the disposal of the appeal. But
So what were you doing?
So, lordship, on that occasion, I was that information not with me, and I placed the.
So now then, when they did not release the money, you have come with the application.
No, I didn't approach also before the Registrar General also. I didn't approach.
So, but this is not the final order has not been passed by this court.
Yes, lordship, but lordship, that court has no jurisdiction. That's why he refused to.
Has no jurisdiction?
But lordship is having the.
So that this can be fixed. No, sir. No, sir. This cannot be done. Let the matter be placed before the court to have passed the judgment.
If lordship
To
will
have
pass,
disposed of the appeal, huh?
if lordship will pass that order, then I have to approach before their lordship, his lordship. But the lordship is not in a position to take up my matter because the lordship said
can fix a date, can fix a particular time when.
you kindly release the matter and take appropriate steps so I can file an application for assignment.
Let the matter be released from the list of this court for want of determination. Determination to hobe na for এরা না ওই যা অর্ডার ছিল তো ঠিক আছে নেক্সট
এটা কি হয়েছে আপনার সমস্ত কি বলুন Lordship, here I have also filed an application after disposal, that is the appeal disposal by your lordship. Appeal, the father of the deceased died, and lordship, I have filed an application for expunging the name of the applicant number, claimant respondent number 2 on death, because the wife is already on record, so only the name has to be expunged. Applicant number 2, the death certificate that I have annexed with the lordship's application.
Where is your application?
Lordship application.
Where is your application?
Application for expunging the name of the applicant number.
When did you file? Sir, there are many matters.
Yes, Lordship. The CAN-C 9/12/2024. আছে তোর মধ্যে আপনার কি সমস্যা হচ্ছে?
Was it disposed of earlier?
Lordship, which is disposed by your lordship.
Then why have you come? Can
I
3
have-
was not disposed of.
No, lordship. No, it has been filed after that.
Now, the judgment is of 13th of May 2025, and you had filed Can 3 on 9th of December 2024. You did not even mention about it.
The matter was under CAV lordship. That's
Oh.
why I have filed this application.
Application is not on list. Let it be on list.
My lord,
Next. Your Can application is not appearing in the list.
the correction here.
Wait.
Paragraph 15 of the order.
No, no.
So you mention it tomorrow.
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 কালকে থাকবে।
Next. No, it adjourned for the degree. Next.
This is my appeal, my lord.
The responding witness comes.
My appeal for enhancement of the award. The appeal on the point of quantum. He's a driver. My income claimed as not 9,000 per month, taken 3,000 per month. In the year of 2014 incident.
Ashok, I have just received
Who
the
has
paper.
filed the paper book?
Well,
He has filed the paper, just served upon you.
Paper book filed by the learned advocate representing the appellant claimant be kept on record. A copy of the same has been served upon the learned advocate representing the respondent insurance company. Heard the submission of learned advocates representing both the parties. Next date be fixed on 24th of September for orders.
much of it.
Next.
Is my appeal. It has come up for correction. Well, there is a mistake in the calculation portion.
What is the correction?
My lord has deducted 5 lakh rupees odd. 3 lakh 99, my lord has written it should be 5 lakh 800 rupees.
The typographical error have without copy paste. No, 5 lakh 3.
My lord is at page last but one page, my lord, the calculation portion. From
Yes.
10 lakh 4,000, my lord has deducted 5 lakh 3,200. 503,200. It will be 500,800 instead of 399.
There is a error in this abstraction.
My lord, only this one.
You just write the number in a slip.
My lord.
Next.
Huh.
Lord, I beg to pay for the petitioner, my lord. My lord, it's an MSCC appeal, my lord. Can 1 is a section 5, Can 2 is a stay, my lord. There's a delay of 291 days, my lord.
Five, 6, 7, 8. Issue notice upon the respondents. Have you given the copy of the challan?
No, my lord.
Have you deposited the statutory amount?
No, my lord.
Then first deposit the statutory amount and come. What a cartoon.
25,000 টাকা জমা করতে হবে।
My lord, that we have. Lord, if your lordship kindly grants us short pass over, I shall take instructions from the short pass over regarding that.
Not today. Next. It was there yesterday. I had adjourned yesterday. You did not come on time. It was adjourned for today, and thereafter, this is your conduct. Next.
But I for the appellant an application still have deposited this application.
Any delay in filing? The report of the stamp reporter mentioned the appeal to have been filed within time and in proper form, and the same is admitted. 4 weeks, issue notice, file affidavit of service, next date, 22nd of September. Next.
Madam, I am preparing for the petition.
For the respondents, my lord, Mr. Pinaki Pulai Bhattacharya is appearing for the Union of India and all respondents. Lord, we have prepared the affidavit in opposition. In reply, all is
Where is the affidavit in opposition?
I have the copy, my lord, but my lord, my senior is on the way, my lord. He just instructed.
File it. Serve him a copy. So this is the reaffirmed affidavit in opposition.
Right.
Your affidavit in reply?
My lord, that was earlier they gave it ready, but I have to reform that. I will take time, my lord. Earlier they have given me, and that was prepared.
So have you got the affidavit in reply ready with you?
My lord.
Reaffirmed copy of the affidavit in opposition filed on behalf of the respondent number 1, 2, and 3, be kept on record. The learned advocate representing. Now, sir, the earlier copy of the affidavit in opposition and the one that you have received today are similar. That you have to check.
Not just now given to me, my lord.
So you sit and check and tell me, then I'll pass you. Just sit and check and tell me. Next.
My lord, I'm led by Mrs. Parmita Mukhopadhyay, appearing on behalf of the petitioner, my lord. My lord, on the last occasion after hearing, we have connected several times with our client, but they didn't reply, my lord. We do not receive any reply from them. Initially, they were interested to continue the proceedings, but after last occasion, that is 2nd May, they are not.
Now, sir, what was the submission on the earlier occasion?
The earlier submission, he intend to move the application. I have filed an opposition. They don't want to file any reply. That's why the matter fixed for hearing. And with a verbal direction, he will supply me a copy of the writ petition and opposition. There's the old matters in 2000.
Who are you?
Petitioner, my lord.
You are petitioner.
Yes.
So they have not supplied to me as of date.
Who is the advocate on record?
Paramita Mukhopadhyay.
Where is she?
My lord, she is.
Ask her to come.
Grateful, my lord.
What the petition?
Yes, sir.
Serious allegation was brought against the petitioner.
Sir, can you please use the mic? The mic, sir.
Serious allegation was brought against the petitioner on the basis of inquiry proceeding was held. And my lord, in the inquiry proceeding, he was found guilty of the charges. My lord, the disciplinary
The
authority,
petitioner was working as
constable,
BISF,
CISF,
CISF.
CISF. Now, my lord, let's kindly come to the final order, which was passed by the disciplinary authority. It is page 108, annexure P10.
Annexure
P10.
P10. Which page, sir?
108.
108. Yes. Yes.
Now, Lordship, kindly come to page 137.
No, in page
The ultimate
108,
portion of the order.
in page number 108, any paragraph you want to cite? Any paragraph in page 108 is of importance?
The final order is, my lord, started from page 108. This is the final order passed by the disciplinary authority. Now, the penultimate portion of the order, your lordship kindly come.
Yes.
197.
197.
137, sorry.
Huh?
137.
Supplementary affidavit. That's the supplementary affidavit. Supplementary affidavit.
Perfect.
Yes. It's
Para 9, my lord.
hence I, that paragraph.
Hence, I, the undersigned, keeping in mind short term of his service and his future in exercise of the power invested in me under Rule 32(1) of the CISF rules, which Schedule 1 do pass the order of punishment that post number such and such oil division shall get a pay scale 4 times lower than pay scale PV1 rupees 5,200 to 20,200 as per Rule 34 B CISF. The salary of rupees such and such being rupees at 5 years with immediate effect, and he shall get no increment during the time he is in the lower pay scale. And at the end of the period, the effect of the lower scale shall fall on his future increment also, and I do pass this order. Portion number such and such 10 is informed that if he wishes, then he can submit an appeal against the order within 30 days before the Deputy Inspector General such and such. Now, my lord, I did not prefer any appeal. I accepted the punishment.
You accepted the punishment.
Now, my lord, the appellate authority, my lord, suo motu issued a show cause notice. Classically, down to page
Was
1.
there any stipulated time period within which you were supposed to file the appeal?
30 days.
You did not prefer an appeal.
I did not prefer an appeal.
And when was the show cause notice issued?
Show cause notice was issued, your lordship kindly see.
After expiry of 30 days?
Yes, after expiry more than 30 days.
Stating what? You did not prefer an appeal?
I did not prefer an appeal. 30 days was lapsed. I did not prefer an appeal.
I can understand, sir. But
Now, my lord,
after, if you have accepted the punishment, then
yes,
then why the new show cause will be?
show cause notice issued by the appellate authority suo motu for the enhancement of punishment.
How come that way? You did not prefer any appeal.
I did not prefer any appeal.
Show me. Show me the document, sir.
140.
Yes.
Show cause notice. As the memorandum.
Now, this charge is similar to the earlier charge.
Same charge.
There is a charge against force number such and such, that while he was posted as court helper, court, KOTE, How is it pronounced? Kote or coat? Kote. What does it mean?
Actually, Kuti.
Kote.
Yes.
What is that?
Kuti means shack. That is the concept actually. Kuti means kotabari in that way. That
How does Kotabari come here, sir?
I believe KOT means
You are creating new definitions. Anyway, helper in HQ sector armory. Now in armory, you get a body.
no, within the Koti, my lord, under one Koti, my lord,
He
there are
carried
some-
out the now. He carried out the weekly counting of arms and ammunitions on 18th of September, 18th of March 2012 and 25th of March 2012, in which 3 pieces of SMG magazines were found to be in excess.
This is the
Instead of-
charge against me. On the basis of
So this
allegation,
is
inquiry
the same
conducted.
charge.
Yes,
Instead of informing the high officers about the said 3 magazines on such and such in collusion which HK Kote such and such with malified intention, he took 30,000 rupees from the other person, Om Prakash Thapa, and posted an industrial center and returned the same 3 magazines which had gone missing from their own armory. The above amount was divided in equal share.
It is the same case, my lord. The
Same case. Okay.
Yes, but at page 142,
Now-
your lordship will find.
One,
What is the reason?
After the
Paragraph
underside reviewed the case file.
Yes.
Now, sir,
This is the
where
case.
is the scope for the appellate authority to review
In terms
at
of
its
50,
own?
my lord, there is
a provision.
Power is there.
Pasha Kali come. Let's
Sir,
complete.
sir, let us go to this
Yes,
page
complete.
142.
I mean,
Page 141. Pasha Kali come to
141.
page 141. Paragraph 2.
Yes.
And as TTGD
Received
One of
the
the Jadov
first.
received the aforesaid memorandum dated such and such through the headquarters sector, and he submitted in written representation of such and such. After examining the sites related to the case, the memorandum statement of the witnesses for the prosecution and the defense, the circumstantial evidence and documentary evidence, and the facts that came to light during the departmental inquiry, the senior commandant CISF unit, while division, found force number such and such to be guilty of the above charge against him, and by final order dated such and such, he imposed the punishment of getting salary at a lower pay scale from such and such to such and such, to 4 scale lower for 5 years with immediate effect, and during the lower pay scale he shall not get any increment, and at the end of this period the effect of the lower scale shall be there on the future increment. Then Lordship kindly come to penultimate portion of the order, paragraph 3. After the undersigned reviewed the case file on his own direction, Lordship kindly on his own direction, he found that taking 30,000 rupees from a colleague and force member in collusion with the court ensured, and giving them in return the very same magazine to them, and that had gone missing from their armory by force number such and such, while posted in such an important place like the headquarter armory in the unit, shows not just his
Crooked mindset.
but is also a serious act of fraud, which has an effect on the other force member and which has been fully proved in the departmental inquiry. Whereas the punishment imposed in the departmental officer, despite the charge force member having been found guilty by the gentle final order dated such and such, getting salary such and such to such and such for 5 years with immediate effect, and while in the lower pay scale he shall not get any increment, and on the expiry of the said period, the effect of his being in the lower scale shall fall on his future increment, which punishment does not seem proportionate and just in context. Now, my lord, my submission before your lordship, that the before passing, my lord, before passing the order of punishment, the disciplinary authority consider the circumstances of the case, in which, my lord, paragraph 9 in the final order, page 137.
So, by the order of this appellate authority, he was removed from the service.
So, my lord, he did not disclose any reason as to why paragraph 9 would not be considered, which was passed by
paragraph
the
9,
disciplinary
sir?
authority. He merely stated the facts, and my lord, merely stated the allegation. But disciplinary authority also considered that allegation. But after considering that allegation, paragraph 9, he passed the order that he should be given a chance to rectify himself in future. That is why his service was not terminated, but he was given a, my lord, the punishment.
So the appellate authority has also given a reason.
But appellate authority did not consider that paragraph 9, that as to why, during considering my short period of service, why I should not be taken up leniently. The view was taken by the disciplinary authority. Under what circumstances the same view was not be considered? What is the reason? He does not
The
disclose any
reason
reason.
is there in paragraph 3, in page number 41, 42. The reason is there. So you just read it out. The reason is there.
And my lord,
Reason is there.
then my lord,
While posted in such an important place like the HQ headquarter armory in the unit, shows not just his crooked mindset, but is also a serious act of fraud which has an effect on the other force members and which has been fully proved in the departmental inquiry. Which shows your acceptance also, sir, because you did not prefer any appeal against the order passed by the disciplinary authority. Whereas the punishment imposed by the disciplinary officer, despite the charged force member having been found guilty under Rule 36 of CISF Rules 2001 by the gentle final order dated such and such, then the punishment has been replicated, such which punishment does not seem proportionate and just in the context of the act of indiscipline that has been proved. That is what the reason the appellate authority has given.
and the appellate authority, my lord, passed the order enhancing the punishment of removal from service.
Yes, sir.
So, my lord, that portion of the final order was not considered, where the disciplinary authority, after considering my short period of service, stated that he should not be terminated from service, but lenient view should be taken. Why this, my lord, circumstances was not considered by the appellate authority? And punishment is disproportionate. And my lord, third point is this, that my lord, where the proceeding was conducted by appointing presenting officer, there is no scope for enquiry officer or investigation officer to make a searching cross-examination. Make a searching cross-examination to the prosecution witnesses. Because for the reason presenting officer was appointed, presenting officer made a cross-examination in accordance with
So
law.
that was in the disciplinary proceedings. You did not challenge that.
What my submitting? That
once you did not challenge that, sir, there is no scope for you to wreck it up at this stage.
No, because I challenged the inquiry proceeding.
You have come against the order of the appellate authority,
Appellate authority.
that the appellate authority on its own accord reviewed the disciplinary proceedings order and passed a final order in terms of removal from service.
But my lord, what
disregarding the fact that the disciplinary authority was lenient enough to only curb the increments, right? That is what your contention is, sir. What else, sir?
রিজনটা হচ্ছে এই দুটো প্যারাগ্রাফ hence having examined the statement
Right,
page
152.
152
Order enhanced punishment was passed by the district appellate authority.
Order of the appellate authority.
The order of the appellate authority, my lord.
Starts from page 146.
146, it starts
146.
Order starts from page 146.
Lordship, kindly come to the penultimate portion.
Yes, this he has himself admitted also.
152.
But now to escape the departmental action, he's saying departmental action? This is the order of which
Appellate authority.
appellate
authority.
authority.
Order that has been passed. First was the show cause notice.
Then he was asked to participate afresh in the disciplinary proceedings.
Before the appellate authority.
Okay, he's saying that the departmental inquiry was incomplete and misleading, which is incorrect from any point of view. Such and such saying that the act of the Narendra Kumar, who had connived with him,
Yes.
the industrial cote helper writing down the number of the notes and handing them over to be a collusive act is intemperate and far from the truth, because it is clear from the statement of such and such that they are certain that the said magazines were with the cote such and such and the charge member. That is why such and such had collected the number of the notes and other evidence and had informed the officers about the money wrongfully taken by the charge member. If the charge member had not conspired in this manner and perpetrated this wrong act, then there was no question of C.T. Narendra Kumar collecting evidence and writing the serial number of notes and handing over them. When the charge member had informed his associates and the Cote NCO about the excess magazines, then why did he enter into a collusion with the Cote NCO and plan this conspiratorial act, and why did he go along with him? It is a factual statement that he had admitted the charges imposed against himself and had thrown light on the incident, but the act by the charge member is of a grave nature and is unforgivable from the point of view of justice. The charge imposed against the charge force member is fully proved by the facts, statements of the witnesses for the prosecution, the circumstantial and documentary evidence in the final order dated such and such of the disciplinary officer. The points raised by the charge member and the defense have been very well analyzed and evaluated, and the charge member has not raised any new points on the basis of which he can get relief. The wrongful act committed by the charge member is completely proved in the departmental inquiry, and he cannot deny that. Hence, I, the undersigned, after having examined the statements of the prosecution and defense, the documents available in the case file, and the reply to the show cause notice, in depth find that the act committed by him is as serious as fraud, and it is fully proved. Hence, I, the undersigned, do uphold the punishment proposed by show cause notice such and such, that of removal from service with immediate effect, and I am removing the punishment imposed by the disciplinary authorities. Accordingly, okay. Yes, what do you have to say?
Page 152 of the entire disciplinary authority finding down. দুটো প্যারাগ্রাফ হচ্ছে যে ওনার রিজন একটা পানিশমেন্ট নিয়েছিল সেটা থেকে যখন বেরিয়ে
Sir, it seems that you are not fully prepared today.
My lord.
It seems you are not fully prepared today.
Yes, yes, sir. Yeah.
Then, sir, you continue.
Well, the point which I raised before your lordship, that inquiry officer is a quasi-judicial authority, is not a prosecutor or the investigating officer. When my lord, the presenting officer is there, he cannot cross-examine the prosecution witness and the charged officer. But in this case, my lord, the inquiry officer acted as an investigation officer and cross-examined the prosecution witness, which is contrary to the principle of law. That was, my lord, decided by the apex court in the recent judgment, my lord, that the apex court says that being a quasi-judicial authority, the inquiry officer must be fair and impartial. He cannot act as a prosecutor. When he made a searching cross-examination to the prosecution witness, that is vitiated the inquiry proceeding. Well, it is evident from the record that inquiry officer himself took the role of investigation officer and cross-examine the prosecution witness, which goes into the root of the allegation. So that is why, my lord, the inquiry proceeding is vitiated in law. This is my last submission.
Yes, sir.
Actually, what I find, my lord, here, their main grievance is with regard to the quantum of punishment. Because so far the petitioner is concerned, he already admitted.
You show me that rule that you've mentioned.
My lord, I didn't bring it today with me.
Hey, Aditya.
If your lordship just kindly come to page number 150.
This is
page 1.
You're referring to CISF rules.
No.
BSF.
This is, I am not showing.
You said rule number 54 or something?
Yes.
When I asked you, what? So give me the name of the rules.
Rule is, my lord, CISF rules. In the act, if there is a bare act, your lordship will take the আমাদের একটা আনিস নি সিআইএসএফ একটা নিয়ে মামলাগুলোতে
এটা বোধহয় চেম্বারে থাকতে পারে, একটা কপি এখানে এনে রেখে দিতে হবে। Yes, any authority superior to the authority making the order may either on his own motion or otherwise call for the records of any inquiry and revise any order made under these rules and may confirm or modify or set aside the order or confirm, reduce, enhance or set aside the penalty imposed by the order or impose any penalty where no penalty has been imposed or remit the case to the authority which made the order or to any other authority directing such authority to make such further inquiry as it may consider proper in the circumstances of the case or pass such order as it may deem fit within 6 months of the date of communication of the order proposed to be revised. So here the revision, if there has been a revision, you cannot say that there has been a procedural lapse on the part of the party to have reviewed. You are only on the quantum of the punishment.
Yes. That no reason. Before modifying the quantum of punishment,
You mean to say without citing any reason, arbitrarily the punishment had been enhanced?
As to why the punishment imposed by the disciplinary authority should not be accepted.
This is
why
your only contention, sir.
No reason was disclosed.
And if your lordship kindly come to their supplementary affidavit from which your lordship, my learned friend was referring everything to your lordship.
Eta diye din na.
Page 150 of the
150. Yes.
Just after 1, 2, 3, 4, 5, 6. After 6 line, my lord. The grounds of the charged member is irrelevant and baseless because when the charged member himself has admitted the charges and exposed the incident and spoken about the 3 extra SMG magazines found in the headquarter armory, which was corroborated by Constables R.K. Saha and such. The industrial armory and armory are situated in the same building and the area of the of the arms and ammunition of both armors are the same. Hence, the main point is not as to how the magazines of one armory reach the other. Instead, the point is that when the charged member was aware of the extra magazines, why he didn't inform his higher officers. So here, my lord, he has already admitted the charges. Difficulty is that as soon as a person, my lord, he admits the charge, then, my lord, the scope of the disciplinary...
You should have read. I mean, you should have continued reading, sir.
Yes, sir. Sorry, I'm sorry. Instead of doing anything of that sort, he conspired with the NCO of the Cote and in a well-planned manner took 30,000 rupees from Constable Narendra Kumar and returned the missing 3 SMG magazines that were not found in the industrial armory back to them. This he has himself
This
admitted
I read
also.
out. This portion I've read out.
Yes, yes, with this person your lordship read. So, my lord, my humble submission is that as soon as you admit the charges, then even if it is the disciplinary authority or the appellate authority, on their part, my lord, it becomes narrow because you are already admitting the charges. Supreme Court is also specific in this matter that as soon as a person, a delinquent, he admits the charges, then there is no further requirement of any proof. Upon his own admission in terms of 58 of the Evidence Act, you can punish him. I will show that judgment to your lordship also. But however, it is up to your lordship. Since my lord he questioned it, and if your lordship take the initial order, where my lord the person maybe he was very much compassionate. So whether your lordship, because in case of removal, he will not get anything.
How long were you in service? How long did
3 or 4 years?
7 years.
7 years.
7 years?
7 years. So naturally, and
now 12 years is out of service.
so, my lord, in case of removal,
You are equally compassionate. It seems
I
you are
leave it, my
equally
lord.
compassionate,
I
sir.
leave it, my lord,
That was
entirely up to
considered
your
by the
lordship.
disciplinary.
Just give me, my lord, one day's time. I will consolidate everything. I will make my submission with the judgments. Thereafter, I will, and there are also judgments that here from, my lord, we cannot curtail it, the punishment. We can advise, my lord, direct the authority if they can, my lord, consider it. It is up to your lordship. I will, my lord.
I'm for the first time I'm finding you to be so compassionate.
No,
Unreasonable.
Why are you so compassionate?
actually, I have my private matters also. So therefore,
Oh.
that is the reason.
Ashun. Sir, you will improve on what you said or on the next date?
What we have, I have submitted, my lord.
Heard the submission of learned advocates representing the petitioner as well as the respondent. Next date be fixed on 12th of August for further hearing. And on that day, whatever decisions or whatever.
Since I will, my lord, submit to your lordship.
Yes, sir. Any problem with 12th of August? Next. Same? Okay. Sir, 1 second. I'll just. এটা হচ্ছে কত নম্বর ছিল? না না এটা কত নম্বর? আমি ওনাদের কথাটা বলছি। Sir, what is your serial number? 27. 27 এর রেকর্ডটা দিন। Copy the reaffirmed affidavit in opposition filed on behalf of the respondent number 1, 2, and 3. We kept on record. The learned advocate representing the petitioner has filed the affidavit in reply affirmed on affirmed on 20th of December 2000. Is it 18 or 16, sir? বোঝা যাচ্ছে না এটা কবে করে 16 20th December 2016 based on the affidavit in opposition based on the copy of the affidavit in opposition served upon him on the earlier date. Be kept on record. The pleadings are completed and in next date be fixed on 11th of September for further hearing. Next. 28 to future. 28 cannot appeal. 33.
My lord, I am appearing for the petition. In last occasion, my lord, the lordship directed to file the clarification. They have served the copy just now.
Nothing new, Lordship, kindly have.
Lord, kindly see the clarification, though it is served here and now, but no clarification has been done.
Clarification has been
Only
done.
the person who is re-engaged as officer in charge. That person has been.
MD korbe, clarification দিলেই তো হলো।
Of course. Well, as your lordship directed,
Well, I think
clarification by the managing director.
immediately within 5 minutes or within 3
Yes,
minutes.
what is your issue?
My lord, clarification made by the nothing has been done. And lordship kindly see.
কি চাইছেন সেই ইস্যুটা
বলে আপনার কথাই আমি তো বলবো না তাহলে কনফিউজ করব that is not just now.
Sir, if it is served to you just now,
Yes.
if you require time to go through it, you say that, or else you tell me something substantial.
First line your lordship kindly see. The person who has affirmed this clarification by affidavit, I am the officer in charge, re-engaged of the respondent corporation. I am authorized to affirm this affidavit. But the question is whether this person is competent or not. That is asking myself. My lordship kindly that is.
Yes, sir, what do you have to say?
My lord, what is the issue, Lordship, kindly consider. In the writ petition, my lord, the prayer is that after having been retired in 2008, Lordship, kindly consider. In 2008, after having been retired, he obtained the gratuity amount which is payable to him under the Payment of Gratuity Act. According to him, as per the government circular, the amount of gratuity should be much higher because of the fact that the cap that was mentioned therein, my lord, may I tell, since it is, my lord, under the pensionary benefit scheme, so there should be a ceiling limit. Whatever be the gratuity under the Gratuity Act, the calculation may be 4 lakhs or 5 lakhs. But if the ceiling is 2 lakh, then he is entitled up to 2 lakhs. At that point of time, ceiling was up to 2 lakh and odd. He was paid. After several.
Retired in which year?
2008. Now he relies upon a government circular, which it appears that yes, there has been raised so far that cap is concerned, but he is not entitled because the date of effective, it should be given effect to only from, my lord, 2008, and he retired in 2006 possibly. Sorry, he retired in 2006. No, retired korlo kobe?
When did you retire? 2006. And the circular or government notification, whatever you are referring,
Yes, given
came into existence in the
from
year?
2008.
Was there any retrospective effect given? Or it was prospective?
Prospective, notional 2006, but actual effect should be, my lord, in my earlier affidavit, I have filed supplementary affidavit today, but my earlier affidavit report, my lord, kindly come to, my lord,
31st January 2008.
everything is clear.
And what was the date of that circular that you're relying
My
on?
lord, it is annexed to my supplement, to my
April 2009.
report in the form of affidavit.
Now, what is this, sir? 17th of September 2009?
That is the circular he is relying upon.
No. 1st April 2008.
1st April 2008.
Relying. This circular.
April 2008.
এই তো।
First April 2008 কি আছে?
Which
Actual effect.
Where have you mentioned that? 1st April 2008. Where is that copy?
Effect will be given 1st April 2008.
কোন সার্কুলারটা
Where is that copy of the circular?
কোন সার্কুলারটা
যেটা
দেখাচ্ছেন
আপনি দেখাচ্ছেন।
আমি কিছু দেখাইনি এখনো আপনি my lord may I tell lordship kindly come to
Show
report
me
in
that circular on which you are relying. Because the circular that you have annexed, sir, it's dates 17th September 2009.
yes I have annexed it to my report in the form of affidavit
Yes.
as well as
Earlier
the
also
today.
You have annexed.
Yes, same. Nothing new in this today's affidavit, nothing new. Now, my lord, kindly come to, my lord, that circular of 17th September 2009. This is with regard to, my lord, subject revision of pay and allowances for the employee of NBSTs, the caption. Have you lordship got it, my lord? Then, my lord, kindly come to, my lord, internal page 3 of the circular. Page 3 of the circular. Have you lordship got it, my lord? The caption again, clause number Roman 8, pensionary benefit. Now, my lord, B, in the case of those employees who are not covered under the Payment of Gratuity Act, existing ceiling on gratuity of rupees 2 lakhs shall be raised proportionately to rupees 4.80 lakh with effect from 1/1/2006. According to him, this with effect from 1/1/2006, then he is entitled to.
No, sir. This
কবে রিটায়ার করলো দেখুন
pensionary benefit,
31st January 2008. Return.
the amount so will be regarded as consolidated pension, family pension notionally with effect from 1/1/2006.
Yes, now come.
With actual effect from one. So
Then lordship
they are
kindly
claiming-
come to the next page. The next page. Page number 4. Under D.
All the above
retirement benefits are notional for the period from 1/1/2006 to 31st March 2008 and revised pensionary benefits.
Actual revised.
Yes, actual revised pensionary benefits will be allowed with effect from 1st April 2008 and he retired on
January 2008.
31st January 2008. So according to the, my lord, the NBSTC.
So what about the notional benefit?
My lord, here since it appears that the actual benefit, that means monetary benefit, actual benefit, monetary benefit, monetary benefit, then he is not entitled to.
What all have you received?
He received, that is without amendment to by this.
No, actual revised pensionary benefits will be allowed with effect from
1/4. That is why nobody has been paid. Whoever retired prior to 1/4/2008 of the, my lord, NBSTC, this is the first time we are interacting with this.
Constitute this part 1/1/2006 to 31st of March 2008.
Then my lord, they remain, my lord, whatever, my lord, prior to this, my lord, the amendment or this GO. That is, my lord, the cap which was.
Sir, retirement benefits are notional. And in any case, they have retired on 31st of January 2008. So the question of notional, the benefits, retirement benefits to be notional or not notional doesn't apply.
Actually, so far this GO is concerned, issued by the, my lord, Transport Department, our, my lord, the
They are
is that
governed by this GO if at all it is effective from 1st of April 2008.
yes, they are not governed. That is our case. They are not governed. So
show me, sir, how you are governed. Because it says it with effect from 1st of April 2008.
Notional effect from 1st January 2008.
But then, sir, you did not retire.
1st January 2008. So I am entitled.
They are entitled for 3 months.
No. All the above retirement benefits are notional for the period from 1st January to 2006
2 months, sir.
to 31st March 2008 and actual from 1st April
No, what they are was there any intermittent period?
Intermittent period, Lordship, kindly consider one thing.
Sir,
there are
let us read it out again. All the above retirement benefits
yes
are notional for the period from 1/1/2006 to
31st of March 2008.
2008.
Yes.
Now, and it will be the actual revised pensionary
Now
benefits.
retirement, my lord, that was my lord done in
It was
between this.
In between. It was on 31st of January 2008. And it would be it would be effective from 1st of
April 2008,
So that,
after retirement.
so they are claiming probably the notional benefit that in in accordance
No,
to the
no,
earlier one for
no,
3 months.
No. Claiming
3 months, March, February,
no.
March. Yes, 2 months. Is it so?
No.
Is it
3
your
months
case?
Yes,
কি বলছে?
Is that your case?
yes. And
Sir, I'm trying to find it out for myself. I'm asking you, you're saying yes. What is your case actually? Sir, what is your case? What is your
Montana
prayer?
benefit say this, in case of those employees who are not covered under the Payment of Gratuity Act, the existing ceiling on gratuity of
That is a different question altogether.
shall be raised to 2 lakhs.
May I take
Which is the circular or notification that you are relying? You have not placed it till now.
Kindly have a look. I think everything will be clear. If you lordship kindly have a look.
Notification.
My lord, the supplementary affidavit filed today, that is, my lord, this clarification. I think everything will be clear.
Which one, sir?
My lord, that is the supplementary affidavit filed today. That is, my lord, page 4, annexure R3. This is, my lord, clarification by my learned friend raising his voice that by the officer in charge or no, clarification made by managing director. Only by affidavit it has been annexed here too, and nothing said in the affidavit. This clarification
So
R3
page 4. Okay.
R3. Clarification of serial number 6 of the exception so filed by the petitioner. In terms of Finance Department memo number such and such of 27 July 2009, Transport Department issued some direction under his memo number of 17 September. Under direction number 8B of the pensionary benefit, it is stated, in the case of those employees who are not covered under the Payment of Gratuity Act, existing ceiling on gratuity of rupees 2 lakhs shall be raised proportionately to rupees 4.80 lakh. He paid 2 lakh with effect from 1/1/2006. At the same time, direction under serial number 8D of the pensionary benefit, it is clearly stated that all the above retirement benefits are notional for the period from 1/1/2006 to 31st March 2008. And actual revised pensionary benefits will be allowed with effect from 1/4/2008. As Sri Swaraj Kumar Basu retired from service on 31st of January 2008, that is prior to the date of actual effect on and from 1/4/2008, on the basis of said direction as contained in serial number 8D of the said pensionary benefits, the calculation of terminal benefits was made notionally with effect from 1/1/6 to the date of his retirement, that is why he was paid gratuity under unrevised ceiling. The calculation of gratuity as given in the exception is perfectly correct, as NBSTC calculation. That is, according to the petitioner's length of service, the gratuity amount ought to have been 5,26,000 and odd. If the revised ceiling was given actual effect from 1/1/2006. But in terms of direction under serial number 8D of the pensionary benefit, he was paid gratuity of unrevised ceiling of 2 lakhs. As the NBSTC is under direct control of the Transport Department, Government of West Bengal, it cannot act without directive or instruction of department. Moreover, Transport Department order under such and such dated just echoes the relevant provisions. So his calculation, whatever, is correct. I am not on that. But that calculation
because of the ceiling.
Yes, beyond the ceiling. Our calculation, his calculation correct. But he is not entitled to. because this pensionary, this gratuity under pension scheme, let's kindly consider one thing. They are under pension scheme, so they are not covered by the Gratuity Act. So calculation under Gratuity Act, but payment should be under the pensionary benefit scheme regulation. And that payment, if there is a cap, unless until that cap is revised, here it is revised, but subject to that rider, that with effect from 1st April 2008. He does not come. He already retired 31st March. What can be done?
So you go.
So nobody has
this,
paid.
You go through it, and if you want, you can file an exception, because this clarification
better.
is there.
That is
Clarification is there. It is quite elaborate. So it considers the points
No,
that
my
you
lord,
have made.
it is-
You are probably claiming rupees 5,26,000
Yes.
odd.
On
So
the
you
basis of
are
the-
you are stating that you will receive beyond the ceiling limit of rupees 2 lakhs. However, rupees 2 lakhs was paid to you, right? So in that case, otherwise I'll fix it for orders.
Others benefit has not been clarified. Others regarding the others benefits, career advancement, then the traveling allowance.
That has been dealt
Because
with
your
in my
lordship was
affidavit,
not
in my
satisfied
report.
Past report, so that your lordship directed the clarification.
No, it
What
was
he
the
has
first point.
said, the supplementary report contains clarification to certain amendments as well as annexure to the affidavit in reply, hereinafter referred to.
So let us not go into issues which are not pertinent to the main writ petition, right, sir? Whatever you must
That
have.
is also my prayer in
Which
the
one?
writ petition.
In the writ petition,
That
that is
benefit.
also some other benefits that has been dealt with that he is not entitled to in my report file in the form of affidavit earlier. Then this supplementary affidavit comes later for the purpose of clarification.
Have you preferred any exception, or you had any counter to
Yes,
the
I have
earlier one?
filed
You have filed. When did you file?
exception file before.
What have you mentioned in it? Yes.
No, B no, Baba.
Sir, in paragraph 7, now you also have come up with the same calculation of 5,26,000 odd.
Paragraph 7, my lord.
Yes. The petitioner has also received payment with regard to career advancement scheme effective
7.
from 1st of September such and such. So the arrear payment, when were you entitled to? What was your date? What was the
September
date?
2002, 31st August 2002 has not been released yet, even though the order clearly states that the payment for this period will be made in due course. That is the exception in the paragraph 7.
Okay, sir, we will continue it on the next state. Sir, you go through his exception also. He's
Exception देखिए.
You have a copy of that exception?
Yes, yes. बताइए.
20, yes, it's in paragraph 7 and paragraph 8. He has mentioned that he has not received the career advancement scheme benefits as well as the TADA. TA, not the DA.
এখানেই তো ছিল exception.
Page 26 of the writ petition, that is their own admission.
Exception তো হয়েছে, নাহলে exception
Page 26.
Of the writ petition. The letter issued by them.
দেখি আমাদের
And the office order number.
দূর আমার মেন রিপোর্টটা কোথায়? এই দাঁড়াও.
This will take effect from.
My lord, kindly.
September.
Yes,
My
that
lord,
will take effect
my lord, it has been dealt with. If you
9/2002, sir.
Yes. And payment.
And payment from, yes, 1/9/2000 to 31st of August 2002 will be considered in due course.
In due course.
So it was not given.
My lord, may I tell? Lordship, kindly have a look, my lord, paragraph number 6, a very small paragraph in my report in the form of affidavit filed on earlier occasion. Report in the form of affidavit. Lordship, kindly, my lord, consider.
Yes.
My lord, paragraph number 6. Insofar as the petitioner's claim for 1,37,000 and odd towards career advancement scheme for the period from 1st September 2000 to 31st of January 2002, the deponent submits that the benefit of under career advancement scheme for the aforesaid period was not extended to the employees of the respondent corporation and or the monetary benefit arising out of the said scheme for the aforesaid period was not disbursed to the employees of the respondent corporation since the same was not sanctioned by the state government, then Art 2 I have annexed. Now Art 2 was a malad the letter malad to the NBSTC malad by the then malad minister in charge. Now malad thereafter malad that embargo was withdrawn malad in 2016, and then again malad the career advancement whatever was due and payable. Then, my lord, in fact, my lord, the yesterday, my lord, the MD himself, my lord, he was present before your lordship in this court, and my lord, he said that whoever was entitled for any earlier period, their cases have been taken up again, and the disbursement has been started. Now, whether he comes within that entitled to, then, my lord, I think, my lord, my lord, again I shall interact with the, so that if he is entitled to, then
He
this
is entitled.
yes,
to,
if he is entitled to, that will be payable to him. If any other persons paid, then naturally he will be paid. So for this career advancement.
Irrespectively, sir, you have issued a notification entitling them to enjoy such benefit. They are going to get it.
Now, my lord, no, so far this, my lord, the affidavit language is that nobody was paid. But if due to certain policy that was taken, subsequent policy, if it is
Sir,
taken.
I do not want to comment.
My lord, I shall take, my lord, instruction on this. I shall take instruction on this. And so far, my lord, petitioner's claim regarding 9,000, 7,000 or it is, my lord, at paragraph number 7, that nothing is lying unsettled. Whatever the bill is deposited.
Anyway, sir, if you can settle it,
my lord.
these two aspects.
My lord.
Apart from that 2 lakh and 5
Yes,
lakh
yes, yes.
issues, if these two aspects can be taken care of you,
I shall.
Otherwise, it will be reflected in the order itself because they are entitled to it. Heard the submission of learned advocates representing both the parties. The supplementary report filed in the form of an affidavit on behalf of the respondent number 1, 2, and 3 in compliance with the order dated 13/3/2025 be kept on record. Next date be fixed on 22nd of August.
22nd August.
Next item number 28 pass over.
Get.
I'll be back within 2 minutes.
একটু বাড়ি যাচ্ছি
28 it was passed over. Your lordship directed her to bring his senior.
Virtual.
My lord, I beg to appear virtually, my lord, with your lordship's kind permission. My lord, I have shared my practical difficulty with my learned friend also, because there was a direction upon me to serve a copy upon my learned friend. My lord, what happened? My practical difficulty is that client had suddenly, the petitioner, writ petitioner has suddenly become non-responsive, and my entire difficulty was that, my lord, the copy which was lying with me, it bears the entire highlight and my extensive notes on it. Therefore, I had wanted to get a copy from my petitioner,
When was
and
this
I
matter
would have
heard?
served.
When was this matter heard for you
My
to?
lord, it was on the last occasion, my
2nd
lord, when
May.
it came to the, my
2nd
lord,
May.
yes, my lord, on the last occasion when it was in the list, just a day prior to that, I had contacted the writ petitioner. At that point of time, he did not tell me that whether he wanted to proceed. I called him, and then my practical difficulty became just after the matter, when I said the matter is ready for hearing, and I
So
was to
your
serve copy.
practical difficulty is well understood, madam. Ashun.
My lord, my lord, my lord.
The learned advocate representing the petitioner appeared online to express her practical difficulty due to non-responsiveness on the part of the petitioner. The What is the issue here, sir?
My lord, it is about the compassionate appointment. That is why his father expired while on duty, and he expired due to accident while he was working over there in his office. Thereafter, my lord, there was a direction upon me to serve upon all the trade unions. I had done so, and that is also being reflected in the order sheet, my lord. When my lord Justice, Honorable Justice Shonji Banerjee was pleased to direct me to do so, I had done so.
Madam, on 2nd of May, you were ready for the hearing, right?
Yes, my lord. Yes, my
And
lord.
accordingly, today's date was fixed.
Yes, my lord. Actually, what happened that just a day prior to that, I had a talk with the writ petitioner. At that point of time, whatever I had sought for, then he gave me those instructions, and I had asked him to come in the court premises and to have the further things. But thereafter, on that day itself, it happened, my lord. And since that date, I have
So
been trying on
it
WhatsApp.
appears to be a disagreement with you and your client, which precluded you to appear before this court today, right? That is
My
the
lord,
main reason.
my lord, there has been no disagreement. It is just that after the matter, I had informed him about this matter being called in and about the proceedings, and thereafter there has been no
The
reply from.
Register Administration LOM is to serve notice upon the petitioner, intimating the next date of hearing for proper representation before the court.
And my lord, at my cost, I will take a copy from her. At my cost. Copy of the
Let the
at my
petitioner appear. Sir, it is understood. Don't you, I mean, with your experience and
Very
with
well.
certain experience of this side,
Very
the
well.
tiff could be understood. Let's not express it in words.
Very well, man, I understood.
My lord, may I
Next
humbly
date
submit?
be next. Where is which is the address of the petitioner? How come Uttar Pradesh?
My lord, that is his permanent address, my lord.
Ghaziapur, Uttar Pradesh.
Next date be fixed on 16th of September. Sir, you enter your appearance.
Yes.
My lord, only one humble submission I am making over here. Since my lord has taken up the matter and my lord was pleased to direct me, whatever be the difficulty with those comments on that, I am going to serve upon the upon my learned friend, my lord. I am going to do it. My lord, I'm grateful, my lord.
My lord, in 35 pursuant to your lordship's direction dated 24th of March, my lord, I am filing the written notes of argument on behalf of the state. I am under respondent number 3 to 5. Now may I handle the copy of this, sir?
For the petitioner, I have already filed my written notes.
This is with regard to the, my lord, compassionate appointment. Your lordship rejected us, and the last occasion I failed to appear, my lord, I was asking, running for another court. In the meantime, matter has been taken. I'm, my lord, extremely sorry for that, my lord. On 24th, your lordship was pleased to direct us.
Written notes filed by the learned advocate representing respondent number 3 to 5.
State and 3 to 5, different.
You are for?
State, my lord.
Respondent state as well as respondent number 3 to 5 be kept on record. Next date be fixed on 21st of August for clarification, if at all.
Grateful to you.
No, I'm
39, Mr. Kajura is appearing virtually on behalf of the petitioner.
I'm appearing on behalf
But
of
I'm for the petitioner.
I am last occasion, my lord was pleased to direct the registered administration to serve a copy of the uh, state respondent, my lord. Pursuant to that, my lord, I have engaged by the department and
So you will be representing?
the state respondent.
State. And CSTC?
I am for the CST led by Mr. Sen.
And yes, was there any earlier direction?
Yes, but there is a query for Mr. Sen, my lord, submitting last occasion, my lord, last order is there, my lord, subsequently see. That is the July, May, 25th of May, my lord's last order.
No.
30th
May.
You had to file a report.
I had also filed a report.
When did you file? When did you file the report, sir?
File opposition, my lord, 227.
My lord, by the earlier order, my lord, the direction was passed upon the state authority, my lord, to seek instruction,
my
lord, on the issue.
2027. My lord, 16 June 2027.
Because the instruction of 227 was that they have forwarded the matter before the state authority, my lord, for payment, and the matter is pending before the state authorities. So your lordship directed the state, my lord, to file a report to this effect.
এটা দিন
I don't think any report was filed, sir.
Opposition, I have already filed. This is a copy
No,
of
no, opposition filed long back, my lord. That is in 2017 or.
So there was a direction on you to file a report. You have not filed the report. देखिए, record है?
my lord, ABDB of rejoinder also filed. On 2nd July 2024.
You had to ask the concerned department about their opinion. You went on taking time. You are not even aware of the matter, sir.
I am not here in the
Where is Mr. Sen?
always code number.
You ask him to come.
May I submit one thing?
Sir, I need the answer to this because they were supposed to file the report long time back. Next. Next.
Lord, I appear for the petitioner. May I,
For the portrait of the
Lord, may I be, my lord, permitted to refresh the memory of the court, my lord. Lord, the writ petition was filed, my lord, by a, my lord, trainee marine officer, my lord. The whole contention was that, my lord, in the appointment letter, a particular schedule was mentioned within which the examinations will be held for the regularization as pilot. My contention was that the examination was not held within that particular time frame, and as a result thereof,
You were also disqualified.
my lord,
You were not successful on successive dates of examination.
my lord,
Yes.
my lord, no, my lord,
Yes.
Lord, I have my lord, documents to show, my lord, that now, my lord, on the last occasion I filed the list of dates, my lord, as my lord, directed
You
by
were
the honorable
you
court,
were
my lord.
not successful on the very first date.
Yes, my lord.
You had been given chances.
Affidavit in opposition, you have stated.
I believe you have prepared a list with regard to their dates and on which date they were not successful.
In the affidavit in opposition, you have stated so.
Yes.
If you lordship kindly have a
With
look
regard
at
to
the-
one examination, my lord, with regard to one examination, with the approval of my employer, the Kolkata Port Trust, I appeared, or I, my lord, took two extra, my lord, chances to my lord, qualify the examination. One examination, my lord. That is the
Now we are. Let's conclude this, sir.
Only, as your lordship is there, only thing your lordship wanted to know on which date the examination took place and
Yes.
when he passed. My lord. That we could not prepare, my lord, these are our latches.
Why, sir?
My lord, that is not that I have stated in our opposition, but your lordship directly.
First 6 months pre-seat
Yes,
training after passing grade 5. Delay of 106 days. I asked you to
Yes, my lord, that-
mention the exact date.
Yes. In our opposition, we have stated so separately. We could not do. My lord, that, actually, this is our latches. Lordship kindly give.
one, my lord, 14.
One
I'll
week
give
time.
you a week's time, sir,
Yes.
because I have given you a sufficient time earlier also.
Sorry, I'm extremely sorry for not submitting the apology. My lord. 1 week time or two
Because
weeks
this will solve the issue.
time. Yes, my lord.
Because they are claiming back wages.
And only 2 weeks time if you lordship kindly grant me.
Now
then
you
we
are
can-
saying that I had been confirmed on such and such date, and you pay me from then onwards.
I was saying, my lord, that since the latches was done on the part of the.
So you are not responsible?
My lord,
You
I
said
have-
there was a delay, but you did not say that you were not successful on the
I
very
have-
first.
Yes, my lord, in the writ petition.
That when it came out,
No,
then
no,
on.
in the writ petition also, my lord, in the affidavit of reply also, my lord, I have indicated, my lord, that so far as one examination is concerned, my lord, I took two extra chances, that too with the approval of the, my lord, respondent authorities.
Page
So far as
90
the
of
other.
petition, my lord, we have given the clear.
No, then on one occasion, perhaps you were not being able to attend also.
Not only that, my lord, he took 26 days within 2 months. That is why, my lord, he could not complete.
My lord, I have, my lord, documents, I have annexed that documents, my lord, which permits the employer to take holidays, my lord. I have annexed those documents. On the next occasion, my lord, when my learned senior will bring.
7 days time, sir. I have given you sufficient time. You do this and file in.
With an advance copy, my lord, then I.
Sure.
ठीक है, sir.
It's not that I have completely forgotten your case. Sir, 7 days. And don't take chances anymore.
This is our lesson. I have said so to the department also. This is very
No,
bad.
it's so weird. that unless and until they are summoned, though there are directions that you can't call them, you should not call them, but unless and until the people from the department are summoned, nothing seems to move.
Nowadays, this is happening. We have told them.
On 4 occasions, the files could not be traced out. And when there was a direction upon the concerned authority for appearance, it could be traced out within few days, where it was being pending since years.
No, this is very unfortunate. They are taking very lenient.
So you tell them if they don't cooperate with you, then on the next date, they have to appear before the court. On the prayer of learned advocate representing respondent number 1 to 6.
1 to 6. 1 to 6.
Next date be fixed on 6th of August for complying order dated 14/5/2025, first passed by this court. I had given you sufficient time.
Obliged.
Next.
Anyway. Great.
My
For the petition in this.
My Lord, 64-65, I am appearing for the SBS TC led by Mr. Owen Banerjee. My Lord, he is.
In so far 64 is concerned.
My Lord, he is engaged in other court, my Lord.
He's always engaged in other courts. Ask him to come.
My Lord, kindly a short passover, my Lord, I am praying for it.
Pick it up at 2 p.m. my lord.
2 p.m. I have other matters, sir. Ask him to come just now. On other occasions also, he has been doing this.
My Lord, I will call you.
You people have started taking advantage of my leniency. Next.
66, 67, I beg to appear on behalf of the petitioner. Madam, I am for all respondents, Madam, Central Bank of India. All respondents, 67, 66 to 69.
66 to 69.
My lord.
You are appearing for all the petitioners?
All the petitioners.
66, 67, 68?
69. My lord, first I must indicate that on the last occasion at the conclusion stage of the hearing, my lord, I undertook to file a list of dates. I have prepared that list of dates, but I find that some pages are missing. So I have to prepare it once again, and I will create.
You also, the same thing.
No, list of dates, my lord. I will file it on the next date, my lord.
Where's your list of dates? How you have prepared? Show me.
It is not, it is.
Oh, this is that bank issue.
Yes, my lord. Harassment matter. My lord, may I just start, and my lord, just I will show my lord the order, and I will rely upon one judgment today. That's it. I will show the act.
You haven't impleaded the complainant as part.
She is the last respondent.
No, he is not being
Yes, yes, on the last occasion, she was represented. If my lord take note of the last order.
Yes, I can see the name. Respondent number 8.
Yes, my lord, in this petition. And in 11, she is respondent number 9.
Yes.
My lord, I will only today, my lord, draw my lord's attention to the statute, relevant portion of the statute, which is annexed to the writ petition. I will only draw to that attention. And first, before that, I will draw to the finding which was arrived at. Recommendation which was arrived at. My lord, first kindly take note of the recommendation which my lord.
Page?
My lord, 53. I am Deblina Basu. My lord, kindly note that I was not served with any copy of the inquiry report. It is only this recommendation which was served upon me. My lord, 53, it starts.
You were not served with the copy of the complaint?
Copy of the inquiry report.
Inquiry report. Yes.
My lord, it starts from page 53. My lord, I will draw directly my lord's attention to page 54, second paragraph. It starts from more so.
More so.
My lord, may I read? More so, it is evident from the report that the actions of Miss Debolina Basu was not in line of behavior as is expected to be as a colleague of the complainant. She should have come forward with such activities which a normal woman would have done in the said circumstances, which she did not. Her action, though not desirable at that juncture, do not come under the scope of sexual harassment, but certainly deserve initiation of action to avoid such representation oblique recurrence.
Repetition.
Repetition, I'm sorry, my lord, repetition and recurrence. My lord, the most important word in this line is do not come under the scope of sexual harassment. So the charges the charges which were brought against me was not proved. Now, my lord, what will be the page 55, my lord, kindly take note of once page 55, the recommendation, serial number 4, Debolina Basu. Initiation of disciplinary action proceeding as a misconduct in accordance with the provision of disciplinary action and procedure specified in the memorandum.
So there were women also.
Women also. 2 women, 66 and 67 are the women, 68 and 69 are the men. They are all colleagues. Well, now, what will be the situation if the charges are not proved? My lord, I will directly take my lord's attention to page 114. My lord, this is the act. My lord, kindly take note of, I'm not troubling my lord today with the other provisions. Section 13, that is at the bottom. Inquiry report. My lord, may I read? I am reading, my lord, from 1. On the completion of an inquiry under this act, internal complaint committee or the local committee, as the case may be, shall provide a report of its finding to the employers, or as the case may be, the district officer within a period of 10 days from the date of completion of the inquiry, and such report be made available to the concerned parties. I was never made available.
You did not receive?
Never.
You were not served with?
Never served. 2. Where the internal committee or the local committee, as the case may be, arrives at the conclusion that the allegation against the respondent has not been proved, it shall recommend to the employer and the district officer that no action is required to be taken in the matter. My lord, I have shown to my lord that in this case, it has been categorically held that it does not constitute sexual harassment or the charges are not proved. Therefore, the action as per the act or the MOS, my lord, I have also MOS is similar to the act, my lord, it is. It says that no action is required. But what they did, they recommended initiation of disciplinary action. So, my lord, this is without jurisdiction and also, my lord, in violation of the statutory provisions. My lord, my first ground. In this regard, my lord, I will rely upon only one judgment, my lord. Kindly take note of. Sorry, 2011 5 SCC 140. My lord, it is in regard to a departmental proceedings, my lord, departmental inquiry. Amongst other, what I will be relying upon today is the provision which has been quoted at paragraph 32. My lord, kindly directly take note of paragraph 32. My lord, will find that at page 156.
Yes.
Hello, it is I'm reading from paragraph 32. It is a settled legal proposition.
Paragraph 34.
32, my
32 at the 4th sitting.
My lord, 32, page 156. My lord, it is 2011 5 SCC 142. May I hand over my copy, my lord?
It is a settled legal proposition.
I'm good. It is a second legal proposition that if the initial action is not in consonance with the law, subsequent proceedings would not sanctify the same. In such a fact situation, the legal maxim sub lato fundamento cadit opus is applicable, merely thereby, in case a foundation is removed, the superstructure falls. My lord, 33 also repeat the same. My lord, why I am relying upon this case?
Yes.
My lord, why I am relying upon this legal principle? My lord has already taken note of the fact that charge was not proved, therefore initiation of disciplinary action otherwise could not have been done. Therefore, my lord, if the initial action is not proper in the given case, subsequently the disciplinary proceeding which has been initiated against me and which has culminated into passing of an penalty of censure will not stand in the eye of law. The entire structure, my lord, because of the initial action being initiation of this recommendation of initiation of disciplinary action is without jurisdiction, the rest of the same will not be sanctified. My lord, I will also rely upon another judgment in this aspect. My lord, it has been reported in 1969-1 SCR 499. AIR 1960 or AIR 1969 SC 395. My lord, here the proposition was that an act required to be done in a particular manner has to be done in that manner. No other modes are, all other modes are excluded. My lord will find this very particular observation or findings of the court at page 3, internal page 3. My lord, internal page 3 starts is part of paragraph 5. Paragraph 5 starts from page 2. The page number is indicated at the top left-hand
Yes,
side.
he did not produce the kind of evidence.
Nothing, madam. Because there was nothing. My lord has seen on the last occasion, I have tried to showcase before this honorable court. There was a complaint. First, I was asked to say what was the event that took place on that particular date. And thereafter, I was issued a notice and I was told that you say what has happened. I submitted what has happened and I even appeared before them and told what has happened. Thereafter, on that very particular date in the evening, I was served with a copy of the complaint directing me to give you a written statement against it. My lord, I submitted that written statement. Thereafter, I was never called. There was neither examination nor cross-examination. Now, in the month of November, my lord, I received this recommendation which I showed to my lord, saying what I have relied upon. Thereafter, my lord, on the basis of that recommendation, disciplinary proceeding was initiated, and my lord, I was penalized with the punishment of censure. So, my lord, in this
you are all of them had been all of them.
The 67 and 66 and 67 censure. 68, my lord,
These are two women.
My lord,
these were those
these
two
two
women.
are women. And 68 is he's a gentleman, my lord. He has been exonerated. Charges were not proved. And 69, that gentleman has retired very recently. Their punishment of reduction of increment.
So the one who has been exonerated, why did he fight?
My lord?
The one who had been exonerated, he has also filed.
Exoneration was during the pendency of the writ petition. Because court directed, there was an order from this honorable court that final order shall not be passed without the leave of the court. So, my lord, and the writ petition will abide, and the result will abide by the result of the writ petition. So, my lord, that was the situation. We have annexed that. We have annexed all those also. So, my lord, today I will be seeking. Lastly, I will be seeking, my lord, an opportunity to file a comprehensive short list of dates because this has turned into 5 pages. But I need a week only. It has been prepared. I need kindly keep it.
Sir, it's yes.
I will conclude, ma'am.
Now Affidavit in opposition has been filed.
Everything has been exchanged and filed also.
What about the private parties? Did they file any opposition?
No, my lord. They have filed one application way back in 2020 itself, can one most likely, seeking a liberty from this court to file an opposition.
My lord, I am appearing on behalf of the private, the victim in this case, respondent number 8. My lord, with regard to the two members who were found guilty of the charges, with regard to them, we have taken out an opposition. Now, that is, if your lordship allows me, I shall hand over. That is in WPA number 10910 of 2021. My lord, this is.
When were you directed to file affidavit in opposition?
My lord, we were never directed. The application was moved. It was affirmed and kept. That is why it was not taken on record. It was not filed because the matter did not come up thereafter. The applications are still pending as on this date. That is why it was kindly since the date of affirmation, it was affirmed on back. But as we
No. Initially, did you decline to file affidavit in opposition?
decline. The order records affidavits by the bank. Though we are represented because the orders records our presence, our submissions with regard to the maintainability of the writ petition, there was no specific direction allowing us to take out an opposition. That is why the applications were filed seeking modification of that order to that extent that we may be allowed to take out this opposition.
So when were you granted the order to file affidavit in opposition?
So that was never taken up. The applications are still pending.
And then when the applications have not been disposed of, how can you file the affidavit in
I have not
opposition?
filed. That is why I have affirmed and it was part of the record. That is why it was not served or filed. Because the applications are pending as on this date.
Sure. For the submission of learned advocate representing the petitioner as well as the respondents. Next date we fixed on 11th of August for further hearing.
Grateful.
And you file that list of dates properly.
Madam, may I be granted liberty to take out the opposition? May I be permitted to file the oppositions in the
No, first of all, let your
application may be hard, madam, on the next.
Yes. You appeared late.
I appeared on the first date only.
Today itself you appeared late.
I was appearing as on another.
So next date you have to get your CAN applications, whatever you have filed, disposed of first, and thereafter. Next. You want to take it back?
No, my lord, kindly.
Mr. Banerjee has come.
সেটা কোনটা ছিল?
64,
এটা কোনটা হলো?
And I'm
Yes, sir.
I'm tendering
Every
my
day you
apology.
do
And
this.
I'm tendering my apology. With folded hands. Kindly you will forgive. My fault.
দেখি।
The matter was not taken up. I'm very sorry.
Today is the date fixed for hearing of the application, which is CAN 5.
What is CAN 5?
My lord, what happened in this matter? Lordship, kindly remember this is a matter regarding, my lord, the promotion of some employees for their, my lord, work during the COVID period.
COVID period.
Now, my lord, the petitioner who is also got.
Was there any specific direction upon you? No.
No. In another matter. My lord, another writ petition, there was a direction, my lord, to release the payment at the feeder rate along with interest. Against that, an appeal is pending.
State is not a party in this matter?
State is party. Mr. Debra is appearing.
So, my lord, what happened in this matter? My lord, I got retired, my lord, from service, and after retirement, they did not release my lord, my gratuity and leave salary, my lord. Now, my lord, I filed a writ petition before this honorable court. Lordship, kindly turn to page.
No, what are you referring to? The CAN application or the writ petition?
CAN application, CAN 5.
Which page?
Yes, my lord.
My lord, may I intervene for a second here, my lord? Possibly my learned friend's client has not instructed him. Gratuity was released. Leave salary is pending. Possibly he has not been properly instructed. Leave salary has not been released. He should have
properly instructed him.
Already yes, my lord. The leave salary is
gratuity
yes, well, the leave salary is still due. Now, my lord, what happened? We filed a writ petition. I filed a writ petition before this honorable court. This honorable court directed them to release, my lord, the leave salary. Now, my lord, they did not release the amount. I filed a contempt application, which is still pending before your lordship. Meanwhile, my learned friend also filed an application for appropriate order, saying that since the main matter is pending. Meanwhile, what happened? তারা কার্তিকের আগে এর অর্ডারটা কোথায় গেল?
Yes.
Lord, may I concede to some extent? My client has conceded so far as payment of leave salary, my lord. My client agrees. They will release at the feeder rate because that is the prayer. Gratuity feeder rate already released. Leave salary at the feeder rate, we shall release. But they also have a prayer for the interest, my lord, on which, my lord, we have already an appeal pending against the order of Honorable Justice Arindam Mukherjee regarding the interest. We say that since this writ petition is pending, so we are not at fault for not releasing the money. So we should not be charged with interest. That appeal is pending.
So then why didn't you come up with this proposition earlier that you are willing to
we
pay them?
We filed application. We filed application which is pending. We filed application.
Because if you don't release them the fund, then how will they pay?
My lord, because it is entirely on the funds. So kindly allow us, my lord, to release
You file an affidavit that you are agreeable to disburse the leave salary. And what else
No,
do
my
you
lord,
want?
My lord, what happened, my lord? Previously,
Gratuity you have received.
my lord,
The
as
other
far as the
benefits
leave
you have
salary is concerned, my lord, when, my lord, in 2022, there was a direction upon them to release the leave salary with an interest. They did not pay that. Now, my lord, to cut short the matter, I'm coming with a proposal: release the leave salary at a feeder rate, at a feeder post. But my lord, the interest I'm entitled for last 4 years.
By the result of the appeal.
Appeal is
No, they are saying they have filed an appeal.
So far as
so that you will be guided by the, result of that writ petition. If they,
my lord, the result of the writ petition, so far as, my lord, my computation would be at a promoted post or at a feeder post. But so far as, my lord, the delay, I'm retired in 2021. Lordship, kindly appreciate last 4 years. I'm a retired employee, my lord, for last 4 years. And the order wherein, my lord, my promotion was granted, that was stayed since 2021.
But my appeal shall become infructuous in that event. If the
Well,
interest
the
is
person, the reference, what I'm, well, the reference of the cases, where, well, I'm paying for the leave salary at a
how
feeder
long will
post.
it take to file the affidavit? 7 days?
I can file the affidavit within 7 days.
And you mentioned about that pending writ petition.
Pending appeal, my lord. One joint
pending
prayer from both
appeal.
the parties, my lord. The main matter, your lordship heard the main matter also substantial. So on the next day, I'll come back with the affidavit. Possibly within a period of fortnight, we shall release the money also. But the main matter was hard. Your lordship called for a report, my lord, regarding the promotions which took place and, my lord, the duties. We have filed report. They have filed exception. Main matter may also be fixed for hearing, my lord. Because,
but, my lord, the order, the reference of the order which I'm taking out, my lord, that the persons, they are also getting the, my lord, their retirement benefit with
What
interest.
do you want to do? You want to compound or make it more complex?
My lord, what I want,
let us carrot it down.
My lord, that is the reason, my lord, I'm praying for the release the amount at a feeder post.
They are saying that they will do that.
But,
Then
my lord, I mean, lordship kindly appreciate the order, which is, my lord, they have
the
preferred the
submission
appeal.
of learned advocate
In
representing
that case,
both
they also
parties,
release the interest.
all the parties. The learned advocate representing the respondent number. You are respondent
2 to
number
4, 2 and 3, my lord.
2 and 3 is to file an affidavit with regard to the claim of the petitioner
My lord.
concerning his entitlement towards leave salary to be computed at the feeder post.
Feeder post.
It was further submitted
My lord,
that
gratuity has been released.
My lord, my client has agreed to accept the leave salary without interest. Let the interest be decided with the remaining writ petition. I'm just taking instruction. Let him pay the leave salary.
We shall pay that. So they agree.
Explaining. it was further submitted that the issue of interest to be paid upon the arrear, it's
No,
the, on the
leave salary.
on the leave salary has been challenged in appeal.
Interest part only.
Only interest.
Only interest.
I have mentioned that. You listen to it first. In an appeal which is pending for final determination. Full stop. The affidavit, as aforesaid, is to be filed by 8th of August.
Well.
Next date be fixed on 8th of August.
Well, meanwhile, let them release the leave salary, my lord. I'm forgoing the interest.
We are taking steps. Maybe within that time.
He will file the affidavit. There will be an order. You will get it.
Well, instead of 8th August, matter will be appear on 12th. But I have some difficulty for medical checkup.
12th.
12th.
But you could. Don't let me call you every time.
No, I'm very sorry, but I'm tendering my apology again.
Next. Every day I have to call you.
I'm very sorry, my lord.
Next.
Kindly accept my apology, my lord.
আচ্ছা এগুলো তো হয়ে গেল রিটার আছে
পড়ে আছে one matter 39 item number 39 my lord that can be my lord.
My lord, I
71.
talked with Mr. Sen. He told me to not to file any report, my lord.
Not to file any report. What does that mean?
Till that he is not to file any report, my lord.
Oh, he has not filed any
He
report.
has not filed any report.
May I submit one thing?
Wait, sir. A matter has been taken up.
My lord,
Yes.
I'm appearing for the Union of India, my lord, in this matter, my lord. My lord, affidavit in opposition, my lord.
Now they have filed the affidavit in opposition, sir.
My reply.
Affidavit in opposition filed by the learned advocate representing respondent number 1, 2, 3 be kept on record. Affidavit in reply to the same filed by the learned advocate representing the petitioner be kept on record. Yes, sir. What is it?
Well, in this matter, I was selected for the post of constable in the Railway Protection Force. Now, my lord, after selection in the Railway Protection Force, they directed me to appear in the RPF training school for completion of your training. The date was fixed. The certain such date you should be attended the training center. My lord, I wrote a letter to the concerned authority that I am in another service, so I tender my resignation. The resignation would be accepted, then I will join. It was, my lord, taken, my lord, 1 or 2 weeks to, my lord, accept my tender of resignation, and then I went to join. But they said that the scheduled date was expired, so I will not allow. The commandant, post commander, inspector was not allowed me. Thereafter, my lord, someone in the said post, they said that when you did not allow the complete the training, you wrote a letter. For that, I will not attend the training. My lord, I do not know. I am a new incumbent. On the instruction of that, I made that letter to the concerned authority. But very well, that letter was not accepted. But again, my lord, the commandant directed me to attend the training, to complete the training of the Railway Protection Force Constable. I attended the training. For 8 months, I had completed the training. I was paid regular stipend. After completion of my training, and I have a good result in the training center, the concerned authority then directed me to go and join in the Southeastern Railway. When I went to, my lord, resume my duty, Southeastern Railway, the IG suddenly, my lord, passed an order that on such an occasion, you made a representation that you are not willing to join the training center. You made a representation and you suppress the fact and complete the training, so your candidature is terminated. And my candidature was terminated. That is the case. Let's say kindly come. I am placing one by one. Well, first you logically come to annexure P1.
Yes.
You have been provisionally selected for the post of constable in Railway Protection Force on the basis of your overall merit position, vacancy, and option exercised by you against the employment notification number such and such. On successful completion of training and subject to fulfillment of other condition, you will be appointed as constable in RPF by the competent authority. Therefore, you are advised to report at RTC CISF Bhilai, Chhattisgarh on or before 6th January 2020 for initial training for the post of constable in RPF. Failure to report on the date may result in termination of your candidature. A copy of terms and conditions. My lord, this is the initial letter. Now, my lord, I was before that, my lord, I was engaged in another department. That is why I submitted my resignation and asked the concerned authority to release me. This is the dated 11 January I was released. Your logically come to annexure P2. Shri Pushpendu Kumar Singh, working in the post of helper signal in pay level 1 under Senior Divisional Signal Telecommunication Engineer, East Central Railway, Danapur, has applied for technical resignation from the present post, owing to his selection for the post of RPF employment notice number such. His technical resignation from 14 January 2020 has been accepted by the competent authority. His lien will be retained in this department as per extant rule.
So you left that job?
Then, my lord, I was
released.
Then I went to, my lord, the join the training center. But when I went to join the training center on my lord, your logical annexure P3, the letter is that I was not allowed, because on 6th January you failed to appear before the training center.
But you did not appear before the training center.
Yes.
You did not appear before the training center.
Because I was not spared. Until and unless I was spared, I cannot join. So I was spared on 14 January. Thereafter, I went to join the.
Were you not aware of the joining date?
My lord, I was aware.
So why didn't you ask them to release you prior to that? So when were you released? You were released on 11th of January 2020.
Yes.
And this is a letter. You were to join on 18th, sir.
18.
No, 11. I have been.
Yes, आपको सूचित
January.
किया जाता है कि संदर्भित पत्र के तहत आपको दिनांक सच एंड सच
टेक्निकल
वो आरटीसी में ट्रेनिंग हेतु उपस्थित होना था, किंतु आप उपरोक्त दिनांक को ट्रेनिंग हेतु उपस्थित नहीं हुए तथा दिनांक 18/1/20 को उपस्थित हुए. Then
14 January I was released. Thereafter I went to join that training center. Now your logically come to very important annexure P4. Very important. That is 27 January. Again I was asked to attend that training center. You have been provisionally selected for the post of constable in railway.
They gave you another chance.
My lord?
They gave you another chance.
Yes.
Yes. Then what happened?
Yes. And my lord, I was directed to attend the training center on 30th January 2020 for initial completion. I attended the training center. I completed the
initial training.
Yes, initial training.
Therefore, you are advised to report such and such for the post of failure to report on that day basis of your candidature.
Yes.
So this was issued to you. Now, did you appear?
I appeared. I completed. Now your lordship kindly come to annexure P6.
Yes.
This is to appreciate that group number 20, including 5 members of the sixth batch of initial training of such and such constable recruits has performed to the best of the members' capacity and achieved the second prize in the world to held on such and such.
Yes, then.
And my name is 5. Item number 5, Suspendusi. So I completed the training. I received the best award. Now, my lord, I went to join. Now, your lordship kindly come to the termination order. Annexure P7, page 25. The recruits constable Sri Pushpendra Kumar Singh was directed by Deputy CSC for undergoing initial course training on RTC CIC Bhilai, which commenced on 6 January 2020. After reporting at said RTC on 18 January, the above named recruit had submitted his application about his unwillingness to continue training, which was forwarded by.
Where is that? Where is that report?
Yes. My lord, that
Where
was
is
not.
Where is that
Yes,
document?
not start upon me. Now,
After
let me
reporting,
complete.
wait, sir, let me ask
Let
him.
me complete, my lord. Let me complete. About his unwillingness such and such. In the white letter number such as himself told me, dated that so. Wherein it was mentioned that Sri Singh submitted.
Did you write anything to them about your unwillingness?
Unwilling, yes.
You have written.
Unwillingness representation is there. Then undergo initial training with a request to his take necessary action as per railway board letter number such and such. Subsequently, his candidature was cancelled by PSC by letter number such and such dated 31st January. Lordship kindly mark it. No such order was passed against me and was served upon me. Surprisingly, in this order, they have mentioned that. Now, however, it was noticed that the above recruit constable underwent initial training at RPF JTC Nasik, suppressing the fact. Mother, this is wrong. That he had earlier reported at RTC CIC Bhilai and had submitted his unwillingness. Thereby, his application number such and such. Sri Pushpendra Kumar Singh such and such was well aware about the rule 53A. 53A is not applicable in this case. As he executed an agreement at the time of his joining the initial course training, his conduct is not satisfactory. How? You have asked me to attend the training. I completed the training for a period of 8 months. You have given me salary, stipend. Now you are said that I have suppressed. On the basis of which? For a period of 8 months, I have continued the training. For a period of 8 months, you have given me stipend. Now you have told that you have suppressed. Then why you have asked me to attend the training when I wrote a representation to you for my unwillingness? The moment that you have asked me to report for training center for another opportunity was given, that representation should not be considered. Lordship, kindly see,
No, where is the letter of your communication? Where is your communication expressing your unwillingness?
Nothing was communicated to me. They said that.
Sir, I'm asking you, where is your letter to them expressing your unwillingness?
Well, that letter is not with me, but it is an admitted fact.
So what one needs to see your language there, what you had written.
Only, my lord, on the instruction, the officer who was present there stated that you wrote that I am not willing to continue the training. Maybe I do not know, my lord.
Now you tell me how far training is related to your recruitment.
How far?
If whether training was a precondition.
Yes. Precondition before appointment.
Precondition before appointment.
If I complete the training
initially
successfully, then I will be allowed.
So initially you said that you were not you were not willing to continue with the training.
Thereafter, the concerned authority again directed me to attend the training, give me an opportunity to complete the training. I attended the training. I completed the training successfully. And the training continued for a period of 8 months. During that period,
So they mean to say that since you had earlier declined to undergo the training, you have lost your opportunity to be appointed. That is what they mean to say.
But after that unwillingness, the next letter, your lordship kindly see, again they stated
your unwillingness must be Must have been recorded by them?
Well, no.
No.
In spite of that, they asked me to join the training center. Lordship, can you see the next letter?
Did they accept your unwillingness through any
No, if
communication?
they did not accept, if they accept my unwillingness, then why they say that you attend the training? That is the letter 27 January 2020. These letters clearly said that you are directed to attend the training, complete the training. So my unwillingness letter was not accepted. Even after filing of unwillingness, the concerned authority gave me an opportunity, direct me to attend the training center. I continued the training for a period of 8 months. They pay me stipend.
Okay, sir. We'll keep it to this. Yes, you will be conducting the hearing or you have a senior?
I have a senior one.
Who is your senior?
Mr. Devendra Narayan Ray. Reading the matter.
Where is he today?
My lord, he is engaged in court number 4, my lord.
What is your name?
My name is Rajesh Kumar, sir.
Are you empaneled?
Yes, ma'am. Yes, ma'am.
You're empaneled?
Yes, ma'am. This is the change brief, my lord.
এটাকে আজকে ফাইল করছো না ঠিক আছে আচ্ছা heard the submission you show me your letter of engagement
My lord,
where's your letter of engagement
my lord, in the mail, my lord.
Heard the submission of learned advocate representing the petitioner next date be fixed on 19th of August, sir.
19th August, yes.
For further hearing. Yes. 78 একটা আছে না?
19.
78. Yes, I am
Grateful.
19th September. 19th August.
Sir, are you ready with the affidavit and reply?
Yes.
I've been served.
My lord was pleased to fix a date later.
No, I make my submission on the points of merit.
The date fixed for actually. My lord, on the last occasion had
let him first file. Where is your affidavit and reply, sir?
Yes.
Chanchal. Affidavit and reply filed by the learned advocate representing the petitioner. Kept on record, a copy of the same has been served upon the learned advocate representing the respondent railways. What is it, sir? Why have you filed? Why have you filed the petition?
It is the order of compulsory retirement from service.
Compulsory retirement?
From service.
Yes.
That's a kindly come. First submission before your lordship that it is the cardinal principle of law that the disciplinary authority first, my lord, frame a tentative allegation against me. Short for reply. After submission my reply, the disciplinary authority, after considering the same, if the authority came to the conclusion that departmental proceeding is required, inquiry proceeding is required to be conducted, then, my lord, the disciplinary authority conduct the disciplinary proceeding. But if the disciplinary authority suo motu announce the name of the inquiry officer and fix the date of inquiry and started inquiry proceeding, then in that event, the mindset of the disciplinary authority is apparent on the face of the record. The apex court, my lord, on this point, my lord, clearly, my lord, stated the rules that what would be, and on this, on the basis of the apex court judgment, the honorable division bench and the single bench of our honorable court has also clarified that you cannot, at the time of framing charges, you cannot name the inquiry officer and fix the date of inquiry. If it is so, then the proceeding is biased and the same is vitiated. My lord, I am giving your lordship the first judgment of apex court. In the case of state of Punjab versus VK Khanna, your lordship kindly come 34 paragraph. I am reading, my lord, then I am giving your lordship the judgment.
আমাকে একটু সাইটেশন দেবেন।
দিচ্ছি। মাথাটা গেল কোথায়? 2001, volume 2, SCC, page 330. Malad, I am sorry, page paragraph 34 is very important. I am reading my lord. The High Court, while delving into the issue, went into the factum of the announcement of the Chief Minister in regard to appointment of an inquiry officer to substantiate the frame of mind of the authorities, and this depicting bias. What bias means has already been dealt with by us earlier in this judgment. As such, it does not require any further dilution. But the factum of announcement has been taken note of an illustration in a mindset. The inquiry shall proceed irrespective of the reply. Irrespective of the reply. Is it an indication of free and fair attitude toward the officer concerned? The answer cannot possibly be in the affirmative. It is well settled in service jurisprudence that the authority concerned has to apply its mind upon receipt of reply to the charge sheet or so forth, as the case may be, as to whether a further inquiry is called for. In the event upon deliberation and due consideration, it is in the affirmative, the inquiry follows, but not otherwise. You see, my lord, page is.
Okay, sir. You can file it at, finally. I have heard you.
Now, my lord, on the basis of same point.
Yes.
Our Honorable High Court, my lord, this judgment is reached its finality. My lord, I am giving the judgment.
আমাকে সাইটেশন
Principle of law has. আমি citation বলে দিচ্ছি 2002, volume 2, SLR, page 266.
SLR. SLR.
266.
266. Let's kindly come to paragraph 14 of the judgment.
Yes.
His Lordship considered the judgment of Supreme Court judgment and then came to the conclusion. In the instant case, it appears also from the memorandum itself that the article of charges was furnished, in which memorandum the authority informed the petitioner that there will be an inquiry. In the same memorandum, the authority declared the name of the inquiry officer and also fixed the venue and time of the inquiry. Therefore, before receiving any reply to the allegation charges leveled against the petitioner, the authority took a decision to conduct the inquiry, and even the authority assumed the jurisdiction of the inquiry officer and fixed the venue and time of the inquiry, which clearly shows that the memorandum containing article of charge has been issued by the authority with a biased mind, and the same indicates its mindset that the inquiry shall proceed irrespective of the reply, as quoted above in the case of VK Khanna. observed in the ethics code in such and such. So, my lord, logically now come to our memorandum of charge. Elect the P1, page 29.
Page
29.
Yes.
So logically, serial number 2. Shri T.K. Rai, Inspector RPF,
Yes.
is nominated as inquiry officer to conduct the inquiry. Then your logically
The petitioner was had been a lady constable.
My lord. Serial number 2, huh? My lord.
The petitioner had been a lady constable.
Lady constable. Yes. Now 3. The inquiry is fixed on such and such date at 11 hours in the office of RPF Force Kharagpur. We should attend the inquiry, which the inquiry will be extracted. So at the time of framing memorandum, charge and allegation, the name of the inquiry officer was declared and the date was fixed by the inquiry officer, fixed by the disciplinary authority.
So she was a habitual.
She was a habitual.
That is the charge against me.
My lord, I'll show how.
Despite the charge, you always attended, sir.
My lord.
Despite the charge, you always attended.
Inquiry I was attended.
Always attended. So these are all false that you were absent for so many days. 37 days on one occasion, 89 days on another occasion, and so on and so forth. No, you always attended. So these were false charges.
No. Habitual, the charge which was given for such and such date is that was, my lord, the leave period, against my leave period, it was, and in some cases I was.
Okay, sir, we'll continue on the next date.
I'll show from the rules that the inquiry
I've
officer.
seen. She was compulsorily
Habituated
retired.
and my lord.
What is her age now?
My lord, just not, that she gets some benefit. That's why they did not. They made a compulsory retirement.
While this writ petition in the year 2022, I was 38 years.
38.
Then I may be 41, 40 or 41.
153(2) allows me to put an inquiry officer.
Anyway, you can show that on the next date. Or the submission of learned advocates representing both the parties. Next date we fixed on 21st of August.
21st.
Grateful.
I appear on behalf of the petitioner. But if for non-payment of provident fund dues and non-payment of provident fund pension, but if this writ petition was instituted. But if during the pendency of the writ petition, several directions were passed upon both the exempted trust fund and also the provident fund authority to provide me provident fund slips. Lordship, that has not been given. However, during the pendency of the writ
So
petition.
you had to file the report?
My lord, we filed out one report. In that we showed out the payments were been done, but still also the last order which was there, my lord, in regard to whether the slip was paid or not, whether the slip was
You
given
have to file that report.
But my lord, we don't have any document because it was an exam.
I had asked you to file the report in the form of an affidavit. So that
Kindly be
would have
2 weeks
been-
be given, my lord.
Why 2 weeks, sir?
My lord, because things are there, my lord. We had been got out the documents which were
When
not.
was the last date given to you?
That was 10th of April, my lord.
Then
My lord, we had filed up with the last occasion. We filed up one
you
report.
had to only file that report in the form of an affidavit.
I'll do it, my lord.
Lordship, during the time when I served, Lordship, it was an exempted trust fund. Lordship, they had filed their report on the last occasion, only one-page calculation. Lordship, that is not the provident fund slips. Lordship, from the one-page calculation, it is apparent that the figure which is mentioned therein was given during the pendency of the writ petition to me. However, Lordship, during my entire service,
No provident fund slips was given. That is my specific prayer in the writ petition. They have not disclosed it. Lordship, the private respondent trust fund.
Did they file any opposition?
They filed the report on the last occasion. Lordship kindly sees the first annexure to the report, Lordship.
No, I probably had given them back the report and
No.
asked them to file.
No, my lord, on the last occasion.
I had kept it on record.
Yes, yes.
Report to them.
I have been given an unaffirmed copy, so Lordship, I am not aware the affirmation date, but it is back sheet says.
No.
Report on behalf of Messrs. Delta Limited, Lordship. It is mentioned.
They had filed it early on 12th of February.
No.
The slips are not there.
No. Lordship,
12th of February we filed.
19th of February they had filed. It is affirmed on 12th of February. That is the Provident Fund report which says that I am receiving my Provident Fund pension.
Now, there is a report on behalf of Delta Limited.
Yes. My lord, kindly takes up page 6. Lordship, this is the only one-page document which has been given, Lordship. During the time when I had served the Delta Limited, they were an exempted trust fund. So all my Provident Fund slips will be lying with them. Lordship, the calculation showed herein, Lordship, is 2,81,308.20. Lordship, this was paid to me during the pendency of this writ petition on 18 January 2023. However, Lordship, I am not even aware that what are my total accumulation. As such, Lordship, I am not aware whether the money they have given me is correct or not. Lordship, I am not aware, and Lordship, they have not submitted the calculation. This is only the accumulated figures of the calculation possibly which they are holding. And if they have transferred to the Provident Fund, those are lying with the Provident Fund.
Provident Fund Authority has been made a party.
Yes. He is Mr. Agarwal.
Party, Mala.
Mr. Agarwal.
No, then who is representing Delta?
Your Lordship, I am
She is.
Your Lordship, leave may be granted to file a detailed report, Your Lordship, so that we can give a detailed calculation, Your Lordship. This report was filed on an urgent basis, so that is why.
Lordship, from 19 December 2022, Lordship, orders are being passed upon her Lordship, directing to produce the particulars of PF accumulation.
Who is she representing?
Lordship, my employer and Lordship, the exempted trust fund. The initial order passed on 19 December 2022.
Where is your exception, sir? You had to file the exception.
Lordship, the one-page report, Lordship, what I will say, Lordship, the other things which have they stated, Lordship, their calculation, they are handing over, Lordship, I am not privy to that. I am not privy to that, whatever they had calculation and whatever they have submitted to the PF authority. I am only concerned about my PF accumulation and the correct figure being given to me.
So you were given more than 3 months' time.
My lord,
More than
my
3
lord,
months'
we are
time.
aware to that. What the documents they have not given to us. The documents because
Who has not given?
Delta has not given because it was an exempted unit. They were been dealing with the entire board of trust fund, my lord.
Who is your senior?
Your Lordship, Ms. Amrita Pandey is leading me in this matter.
Where is he?
Your Lordship, she is appearing in court. She's attending in another court, Your Lordship.
My lord, because it was an exempted unit.
What is her name?
Ms. Amrita Pandey, Your Lordship.
What Pandey?
Amrita Pandey.
She never appeared. What's your name?
Neha Singh, Your Lordship.
You are appearing for the first time today.
No, Your Lordship, I had appeared in previous sessions.
Who is Bipasha Jaiswal?
Your Lordship, she is my colleague, Your Lordship.
So every other day somebody new comes in. Hey,
Lordship, will kindly see 19 December 2022, the first order wherein, Lordship, they were directed to produce documents and particulars with regard to Provident Fund accumulation of the writ.
Is it a hide and seek game being played on? Then every other day somebody else comes.
Your Lordship, Ms. Anamika Pandey also appeared on the last occasion. Her name has been wrongly recorded in the name of petitioner, Your Lordship. Kindly see the last order, Your Lordship.
You have not complied with the order. Are you conversant with the facts and figures of the case? Tell me what is it? Tell me. You're arguing? You're in a debate mood? Where is your wakalatnama?
Your Lordship, my senior had filed her wakalatnama.
One to have any. No, one to have any. One.
No, they had been granted earlier also.
Lordship, on 19th December 2022,
Yes,
the
from
first
that
order. The first order.
Learned advocate representing the petitioner is present. The Register Administration LOM is directed to serve notice upon the respondent Provident Fund Authority as well as the Delta. The Delta Limited to serve notice upon
Malad, the Provident Fund
upon the to ensure their personal appearance online on the next date of hearing and to explain as to why order dated 19/2/2025, 28/3/2025, 10/4/2025 have not been complied till date.
But we had complied the order, my lord. We filed up the report on 19th of February 2025, my lord, as per your lordship direction. But the
Next date be fixed on 13th of August for personal appearance online.
Madam, the personal appearance for the Provident Fund, madam?
Yes, as well as Delta. But you have not. I had given.
We had filed a report. Kindly be taken into consideration, my lord. We had
the
stated,
report had to be filed. If you have
my lord,
filed
we
the
don't have the slip, my lord. This is the thing which they did not give out the slip because it was an exempted unit, my lord. They were dealing, the board of trust of the Delta was dealing the entire facts, my lord. In that case, they had all the documents. When ED had made out a raid, they did not pay the past accumulation. There were 25 crores of past accumulation.
Do you file an affidavit to that effect that they have not given
If
you?
that can be, I can file out the entire thing, my lord. But in regard to the document of the slip, my lord,
you mentioned that,
my lord, kindly be taken. The personal appearance should not be given. I can file up within a week. If it has been given, granted me a 1 week, I'll file up the entire facts of the case. That can be done, my lord. But
so you people don't do that unless and until there is a.
Your lordship has directed me to file up the slips, my lord. The slips.
Yes, I also had asked you to get in touch with them.
My lord, they are never had complied. Even the past accumulation of 9 crores are still pending, my lord. They are not dealing. They are not paying the money, my lord. What they say, they don't have the money in their hands. Even in the matter was taken in courtroom number 30 also before Honorable Justice Sampadat, my lord. There also they made a submission, my lord.
The learned advocate representing the. You are respondent number?
Respondent number 1, my lord.
Respondent number 1, Provident Fund Authority submitted that the respondent number
2 and 3. 2 and 3 is the one.
2 and 3 did not cooperate with the learned advocate representing respondent number 1 in supplying the slips relating to the Provident Fund disbursement pertaining to the petitioner, whereby the the learned advocate representing the respondent number 1 could not file the report in the form of an affidavit. The learned advocate representing the respondent number 1 is to place the entire status in the form of an affidavit on the next date of hearing. Next date be fixed on 1st of August. This much you can prepare,
yes, madam.
Right?
1st of
Delta, yes, 1st of August. Delta appearance. 1st of August.
Deeply, sir.
Yes, sir. Forgot about the report.
No, that is not. I have not, my lord, forgotten. No, my lord, my lord,
39.
না না এটা আগে দেখে নিন
ঠিক আছে।
39.
My lord, 39, lordship, kindly, my lord.
রেকর্ডটা দিন
24/24 24/24 পরে কবে হলো?
30.
20/11/24. My lord, kindly, my lord, have a look to my lord's order.
Sir, it was last on এটা Bikash Ghosh and others.
Yes.
12th of December 2024, sir.
Yes, 12th of December, একটু আগে দেখলাম।
So you had submitted that the some ministry or some department was contemplating.
Yes. My lord, now, my lord, before that, if your lordship, my lord, kindly have a look. My lord, the order dated 20th November 2024.
20th November.
My lord, just my lord, the preceding order, 20th November 2024. That's the earlier order. Because CSTC disclosed that 2 back-to-back letters were written to the Transport Department.
Yes, sir. Then you said
Now-
that the concerned department of the state were
They have
sitting
not
on
yet-
that issue.
yes,
They were
not yet-
contemplating and they were yet to come to a final decision.
Yes. And then after that, my lord, that order was passed on 15th of December
And still
2024.
it's not appearing.
Yes, state at that time was not appearing.
Today you have come, sir. That too.
I do not know, my lord. After notice,
Now, my lord,
I have to
now, my
come.
lord, since nothing communicated to me, that is to the CST, so no report can
But
be
then,
filed.
sir, you had to communicate with them. That was the
No, the communication logically.
yes,
Well,
file a report as to the steps taken by the government. I asked you, sir, to
My lord,
take it
kindly-
on your.
Kindly have a look, my lord's order.
I know, sir.
20th November.
I know, sir.
Department was directed. The
Sir,
department
please
directed.
listen to me.
My-
It was discussed that since the state was not appearing, you will on your own status try to find out the status. This was the submission, right, sir? And thereafter,
My lord, kindly. My lord, excuse me, lordship, might have been that it was.
yes, this was what was discussed, sir.
My lord,
I asked
I
you
agree
to
to that.
get the information
My lord,
collected
no.
from
I
your
cannot-
court
yes,
on
yes,
your
normally
from your
it is
account.
done and it has-
Yes.
if it was, my lord, I cannot.
Now, sir, you assist him now that you are in the picture.
Yes. Now, my lord, this is the state report pursuant to the letter given by the CSTC. This is our reply.
They have given
Reply
you
দিয়েছো?
reply.
Yes.
আমি কিছু পাইনি তো।
No, no,
রিপ্লাই
no.
দিয়েছো? CSTC
Before your
কে?
lordship, my lord.
ও আচ্ছা আচ্ছা। ও
What is this reply, sir?
This is a memo referred by them. It is not applicable.
Now, we had
to-
approached the department for consideration of their pair for contractual engagement and said as much as he is not in a position to recruit any person in whatsoever capacity without approval of the government. So this was the letter communicated to the secretary government of West Bengal. Now, what is the reply?
This is the, my lord.
Wait, sir.
Page 3, this is the letter.
Opening
না না
provision.
দাঁড়াও 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 আমাদের
No,
আগেকার
it says
রিপোর্টটা
the
দেখি।
provisions of this order will not be applicable where contractual engage has been made without any sanctioned post
এটা
and
কে
for
দিল?
any
এটা
specific project for a
opposition।
very temporary period up to 6 years of finishing up the project,
ওদের।
whichever what project.
আমাদের দুটো চিঠি অ্যানেক্সচার করা ছিল না, সেইটা কোথায়? দেখো তো।
Sir, is this the manner in which
No,
they?
no, no. I am just, my lord, I asking leave
Well,
to file a report.
No, my lord, may
I am asking you
I
to find
think
a
So these letter
these
one.
letters, my lord,
Page three, this is the letter.
the letters annexed to the, my lord, my affidavit of rejoinder. The caption is affidavit of rejoinder.
So your letters were
My
one
let-
of 15th July 2022
Yes, yes, yes.
and the other one was 22nd of May 2024.
My lord. 2nd May 2024.
Yes. This is the letter, my lord, page 2 and page 3 of my report.
ও রিপোর্টে অ্যানেক্সটা করেছো?
Now they say that
the volunteer training.
ভলেন্টারি, হ্যাঁ।
so you file this in proper form, serve them a copy. Sir, thereafter you file the final report. Ready. So this is your reply to those two letters.
Yes, this is my.
Right?
This is.
So first of all, you have to communicate that to them because they had written those two letters. And thereafter you file it before the court.
First, we have communicate to the CST.
Yes, sir.
One.
Because that is something which you have to do primarily because
Definitely, I have to do it. But it is well, my lord's court's order. That is why I have to
not
now-
the court's order, sir.
No,
Court's order is subsequent. They had written to you. So you have not replied to them for so many months and years, if I'm not wrong.
No, you have lordship correct. Correct. Absolutely correct, brother. I am lordship.
No, no.
The learned advocate representing the
এটা ঠিক অ্যান্সার হচ্ছে
state
না, এটা অসুবিধা হয়ে যাবে আবার।
has to reply to the letters dated. Yes, sir.
Because I also, my lord, want to solve the problem, but my lord,
Yes,
so
sir.
far I have gone through this, my lord,
This is absolutely inconsequential
and will not serve purpose of anybody, my lord, neither the court nor the, my lord, petitioner, anybody. So, my lord, better let them give answer to that letters written to them specifically.
That's what I'm asking.
My lord, my lord.
That's what I'm asking.
My lord.
It is Joseph বললেন প্রথমে যে আমাকে তোমাকে দেখছি।
The learned
এটা হবে
advocate
না, এটা
representing
তো
the
তোমার
state
এটা
is to furnish reply to
সম্পূর্ণ
the is to
আরে ওই
advise
চিঠির সঙ্গে এই মেমোরান্ডামের কোনো
concerned
সম্পর্ক নেই, একটু ভালো করে
department
ওদেরকে
to
বলো তো,
furnish
কেউ
reply
দেখেনি।
to the letter
আমার
dated
ম্যাচে পড়লে ভালো
2/5/2025, 2024 and
ম্যাচে পড়লে বললো তোমার অফিসার দেখেছো?
no, 25 now. Letter dated 15 July 2022 and 2nd May 2024. Addressed to the
দেখি আরেকবার
it was addressed to which department? Addressed to the
না আমার
Managing Director, West Bengal Transport Corporation. Presently, it was erstwhile CSTC, sir.
Transport Corporation, madam.
No, CSTC
আলাদা আছে?
Erstwhile
ট্রান্সপোর্ট
CSTC.
কর্পোরেশন হয়নি, অনলি এটা হয়েছে, সিটিসি হয়েছে।
Positively within a week and file an affidavit to that effect. You have to reply to that to those two letters. এটা ফেরত দিয়ে দিন। The learned advocate representing the respondent, West Bengal State Transport Corporation,
Calcutta State Transport.
the CSTC. So, sir, it is now CSTC.
No, all along, madam, may I tell, all along CSTC, Calcutta State Transport Corporation, since, my lord, 1962.
But then you have written here WBSTC
My lord,
in bracket CSTC.
madam, may I tell, my lord, once, my lord, there was a threadbare discussion that whether, my lord, it can be, my lord, under the one umbrella of the State Transport Corporation. But the difficulty is this, my lord, that there is a statute. So there is a statutory bar. Then, my lord, matter can be placed only before the, my lord, the parliament. Then only it can be done. So that is why it has not been done.
So it is not
Because-
erstwhile কতটা কেটে দিন
No, it is not erstwhile. All along, all along.
erstwhile টা কেটে দিন West
All
Bengal
along
Police
CSTC.
Transport Corporation
But the problem is that sometimes, sometimes, my lord, what happened? The officers, they, my lord, serve CSTC as well as CTC under the Transport Corporation.
CTC is a tram.
CTC, Calcutta Tramways Corporation. That, my lord, all, my lord, because the Calcutta Tramways Company Limited, 1971. The company can be transferred, but not this corporation, which is under the 1950 Act. There is a provision that if the corporation, my lord, merged with or mingled with any other, then, my lord, it should be placed before the parliament. That is why.
Acha, is to thereafter file a comprehensive report in compliance with order dated Well, 2011-2024. The learned advocate representing the petitioner is present online. Let them serve and then you'll receive a copy. What he's saying is he's inaudible. Next date, 11th of August.
12th.
Oh, 12th August. 12th of August.
No, no, তার আগে কি বললাম? 20th?
Next.
No, 20th.
FMA.
Matter will appear on 20th November.
12th. When 20th November?
My lord.
নভেম্বর করতে গেলে
12th August.
12th August. My duty is only to communicate the decision.
Reply properly, sir, not in that
No,
language.
not language. I do not know, but
I should not be commenting on it, but the language is absolutely incomprehensible.
Correct. Absolutely correct.
Get
next.
Much obliged, sir.
করে দাও না একটা ছেলেগুলো করে দাও ছেলেগুলো ছিল
জমা নিলেন
This is my appeal for in of the award on the ground that
Where's your other side?
Mr. Porimal Pari.
Where's Mr. Pahari?
He took in the morning when he took adjournment on.
Yes.
My lord, I kindly grant 4 weeks time to file the paper book.
On the then why did you mention? Why did you mention?
My lord, because the LCR has come, my lord. But
The learned advocate representing the appellant claimant is to file the paper book
Lordship,
by
kindly,
21st of August.
my lord, well, Lordship, kindly see whether the PCR has come or not.
TCR is was it called for? It's of which year?
It's of
2012.
9. 12 is FMA.
Your appeal is of 2009. 2012. Esche TCR? Tale TCR call for 20. It will come from which district?
My lord, it is a district of Paschim Medapur.
Okay. 21st of August.
21st house, how in the mean? Yes.
Now this one is ready.
Yes, well, I am filing the paper book. Paper book has been served upon my learned pen.
Paper book
Well,
filed by the learned advocate representing the appellant claimant,
for
serving a
one-
copy of the same upon the learned advocate representing the respondent insurance company be kept on record. Yes, now tell me.
My lord,
My lord, I'll have to take some instruction from my client, my lord.
my lord, it is a point of my lord that medical board issued 70% is a amputation case. But the learned
You
tribunal
people have kept it pending since 2016. Amputation matters and all.
2014. Amputation matter
20, which one? 2014.
Eight.
8 is 2016.
FABT 2014.
So if it is of 2014,
Malad,
it's
the
more than 10 years.
LCR has not reached, Malad.
10 years NCR has not reached.
Malad, the LCR has recently, we have to, we had
PCR is chair.
LCR. Paper book, Malad, today
You
I
have filed. Now tell me, why are you going back? 70%?
70% disability assessed by the
Amputation?
medical board. Is a case of amputation.
Huh.
Run
Amputation of?
Amputation of my lord the one leg, my lord above knee, and my lord the no future prospects, no my
That
lord.
time future prospect concept was not there.
Well, 2014.
17 a year.
My lord, the future prospects from 1991. Even if my lord the
No, if you say about, if you are in terms of this Pranay Shetty's.
Pranay Shetty, my lord, is one accident took place in the year 1986.
But the judgment was of late.
Judgment of 2000.
Anyway.
Let it appear as forwarders, my lord.
Yes, madam.
My lord, I'll have to take some instruction from my client, my lord.
What instructions? Whether you will proceed or not?
My lord.
You had filed the wakalatnama?
No, my lord.
No.
My senior was appearing in this matter. That's why all the matters my senior
His
was.
father now expired, my lord.
You have not yet filed the
No,
wakalatnama.
my
You
lord.
should have told me that earlier. ওটা কেটে দেন। ওই serving a copy টপি গুলো সব পুরোটাই কাটুন। Paper book filed by the learned advocate representing the appellant claimant be kept on record. Next date be fixed on 4th of August. By that time, you file the wakalatnama and then come. Then I'll fix the next date.
I'm grateful, my lord.
My paperwork file be kept in.
Next. আজকে পাঠাট কিছু আছে নাকি? এটা কেউ নেই তো। দেখি। আচ্ছা, none appear to represent either of the parties. Let the matter be fixed under the heading to be mentioned tomorrow. Next. Same order. You are for?
My lord, opposite party number 2, the complainant in this matter, my lord.
This is that compromise issue, right?
Right, my lord.
Yes, madam.
Led by Mr. Raj.
Even after spending so much money on it, wanted to quash the proceeding on the basis of the compromise, which was never effected. Since 2013, there are series of, that's why affidavit was filed. They have also filed affidavit after Puja vacation. 2013 matter, they are not interested.
No, then at least we have to finish it off, sir.
Absolutely.
Yes, where's your senior? You.
Anand issue, my lord, is in courtroom number 26, your lordship. I'm praying for a short Passover.
Passover. Again, my lord, for 446, it will not be possible for me, my lord.
No, then tomorrow, my lord, kindly.
So I'll adjourn it for tomorrow, so that we. Yes.
My lord, there's a CRAN pending, my lord. We had filed a CRAN. My lord, learned friend for the opposite party number 2, we had contended that the company has been struck off. Now we had filed documents with regard to that. Thereafter, my lord, the opposite party number 2 had filed an opposition, rejoined to the said supplementary, and produced before your lordship a copy of the order passed by the learned NCLT Kolkata. Now, my lord, if your lordship peruses that order, if your lordship sees, my lord, that order in fact has not been given effect to. There was a direction by the tribunal that my learned friends would take steps so that the company can be revived. It's still struck off, and we have been instructed that they have not taken any steps with regard to the purpose of revival of the said company.
But
Now, if
who
the
has not
company-
taken steps? The person who is appearing, his application, his suit is pending, claiming the ownership of the company in 2001.
That is not the point, my lord.
That's why, my lord, in one
I'm not
hand,
finished. I'm
he
not
is
finished.
claiming the companies,
No.
filing suit.
So that,
And in
my
other
friends
hand,
have also
the
claimed.
revival is on the other our part, who has paid the
to be.
entire money, and now we paid for refund of it. Well, that's very
But a
innocuous
company
prayer on
which
the
is-
part of the
A
petitioner.
company which is not in existence till date. This was my learned friend's specific submission that the company has been revived by an order of the learned tribunal. Now that order was placed on record. If your lordship sees that order, my lord.
I can't understand you people. Why are you on the periphery?
No, periphery, because my lord, he
You
doesn't
are
have
on
a
the
locus.
periphery. Let us come to the focal
He
point.
doesn't have the locus,
For the
my lord.
quashing issue.
Absolutely.
My lord, we are ready and willing for quashing application hearing if the state is represented. My learned friend will have no
Who is
locus.
appearing for the state, Mr. Vidyut Kumar Roy.
My learned friend will have no locus. That your
Yes,
lordship
my
has.
lord, I have the locus. I shall satisfy that.
A
Sir, you
person of-
asked Mr. Roy to be present. His presence is necessary.
Absolutely.
Was
my
he
lord-
earlier asked to be?
No, there was the
Present.
case diary was given to your lordship. I think the
Now,
Xerox
subsequently,
copy of
it was
the-
returned by my lord.
Oh, that was perhaps then.
Because
Was repeated prayer for refund.
Yes.
Oh, then that must.
So he had to. I mean, he was supposed to file a copy because he was filing the original one.
So, my lord, we have just filing our reply to the rejoinder filed by my learned friends. my lord. We had given them a copy. my lord.
So you want to prolong?
Yes.
It's not prolonged, my lord. Lordship, a company which is not in existence.
Your
An
issue
affidavit is
is
affirmed by that person. How is a constituted attorney at all affirming an affidavit on behalf of a company which is not in existence? For that, my lord, we had filed a. My lord, peripheries are important because here,
Yes, sir. Now come. You have the last order with you.
my lord, clarification. Your lordship had asked Mr. Bhattacharya about.
Paragraph number 2. So is that the reply? Is it the reply to paragraph number 2?
No, my lord, this was prepared because they had given a rejoinder.
No. So then where is the reply to this, sir?
No, reply to this was not in the written form. I don't think, my lord, we had understood this as a written form instructions, my lord. We had sought the instructions from the clients. We are ready for the hearing.
So where is it?
But the difficulty is, since my learned friend does not have a locus, my lord, here we'll have to join issues, my lord. Understanding the fact that the company, which is the opposite party number 2, which had entered into an agreement with us, is not in existence.
So
at-
you mean to say presently they are not in existence?
They're not in existence.
But at the time of entering into that compromise, they were in
But,
existence.
my lord, rejoinders are being filed in 2025. How is the person affirming the affidavit if he doesn't have the power? Who is giving him that power?
Yes, sir. What is your
An
answer?
affidavit has been affirmed on oath.
What is your answer, sir?
Well, my answer is very simple. I have invested funds in purchasing the entire company, which the petitioner claimed, being the owners. From 2001, there are suits pending. Interim orders of status quo is there. Subsequently, non-filing of the returns by the concerned persons who is claiming to be the petitioner herein. being the director of the said company, did not filing, this company struck off. One of the shareholders had made the applications and it got revived on his prayer because he was one of the deprived of that particular shares. If the learned court directed for revival and a person who is claiming to be the director and claiming the ownership of whose duty is to perform, is to shut away from the court, and only in claiming the benefit of such non-revival in a criminal proceeding where the signature is being forged by this petitioner, the allegation is specific against him. Our issue is that the compromise what they have prayed for in 2013, that compromise has not affected. After 8 years of long arbitrations, award has been passed.
That is under challenge.
That may be challenged, but that what prayer you are making before my lord, that on the compromise this quashing application is to be heard. And now I brought on record that 2001, in one hand you are claiming the ownership of the company, and in 2025 you are claiming that that company has been gone, so I should be let off. These both stand cannot go together.
I'm sorry to join issues, my lord. It is not about his being and I being only my hearing be completed. I do not.
Okay,
say
sir.
that.
Let us ask Mr. Roy to
Mr.
place
Roy,
the
we place
case,
the case
the
diary.
case
And
diary.
your
Yes, there
lordship,
your lordship
once and
dispose
for
it off.
all, lordship,
If
our prayer is
investigation so far the criminal proceedings
Sir,
subject to
he
correction.
must be around somewhere.
Maybe I shall inform. Not without one, the ball has been started. Investigation initiated. At the time initiation, everything was there. Now the initiation.
You have that order of revival with you?
Yes, it's part of the.
I have already annexed. Yes, I have.
It's part of the records. And
So you mean to say, by virtue of the order of revival, you are capable to affirm, right?
Malad, if I can just place that portion of the order, Malad, if I may just.
Where is
that
it?
clarifies, Malad. That's part of their rejoinder to the petition that we had filed, to the affidavit that we had filed. That's annexure R1, page 14, Malad. The one that Mr. Roy Chaudhary had filed on the last occasion, I think. Malad. A copy thereof is with us.
What is the date?
Malad, the date
of
is
rejoinder?
19th of January. Oh, the date of the affidavit.
No, you are mentioning that rejoinder. What is the date?
Malad, I don't have my copy does not have date.
In 2024, it was filed. It was not the last date.
It is affirmed on, I think, 2nd of April 2025.
Is it 5th July?
Yes.
5th?
Yes.
No.
5th July 2024?
Yes.
This, in my copy,
Yes, which page?
5th July, আমাদেরটা না তো?
Which page?
আমাদেরটা দেখ কবে এখন? Malad, page 14.
Page 14?
Page 14, R1. I think your lordship is going
Page
through.
14, no.
No, that is our, I think this is our reply to the rejoinder. If it is 5th July, it must be our rejoinder, Malad.
This is the one which you have filed today. 2nd April.
2nd April is perhaps their one.
Okay.
2nd April 2025 is the one filed by Mr.
Page 14.
Yes, Malad.
Yes. Order is of.
Malad, this is of 19th of January 2024, Malad. The lordship sees the parties, Malad. Park dealer is the struck off company.
Yes.
The appellant is some other entity named Omnitech Engineering.
Yes.
He is also in dispute. The arbitration of
No, show me that operative portion.
Malad, it starts from 6.8.
This is the order of revival.
This is the order of revival my learned friend is harping on, Malad, which gives him accordingly the power. Now let us see, Malad, how. Malad, see, accordingly in
Yes, the Registrar of Companies,
yes,
West Bengal, the respondent herein is directed to restore the original status of the petitioner company as if the name of the company had not been struck off from the register of companies, with the resultant and consequential actions like changing status of petitioner company from struck off to active.
And next
So
one,
that
see,
is
these are the preconditions, my lord. B, C, D, E, these are the preconditions. The restoration of the company's name, if your lordship sees.
Then what is your problem?
That it has not been done. In spite of an order being there from the NCLT, my learned friend claims I should do it. We claim that they should do it.
Wow.
Now the company is still struck off. If the name is still struck off, and
So you have not
they have not
taken
done
any steps?
No, nothing. Neither the appellant Omnitech have taken step. The appellant
not take steps.
so they will not take steps. And who are the other parties? Lordship comes back to.
So you seek clarification from me.
My lord, now your lordship, yes, on the struck off
Operative portion.
order. Now your lordship yes. Now your lordship comes to the my affidavit at page 8.
8.
The averments.
Please wait, Lord Mr. Anand.
Yes.
These averments I have given, I have annexed. This is the plaint of 2001. I am not troubling your lordship.
Annexure, page number.
But now I will. Now your lordship comes to 9, next page. Now see the prayers.
So what is the order?
Here the status quo to be maintained.
Where is that order?
That order I confirm this. Now see the
So
defendants
these
who are the
so
item.
these are your prayers.
Yes, these are his prayer, not my prayer. He made the ownership on that particular before this honorable court in the original site.
It's not declared as of yet, my lord. These are pending.
It will
issues.
never be declared because
these
you have
are
never
pending.
invested a single paisa and you are enjoying the entire property.
Merely
And that's why, my lord,
shouting will not.
no,
create
certainly.
his
No, sir, what action have you taken? I mean, what steps have you taken in
Lord,
that?
we have filed our WS. Now the suit is ready for hearing.
No, you produce that status quo order. You place that status quo order because they are challenging your status of contesting this application. If that be the case and you are claiming that you have been revived, so sir, though that order itself is good enough, but nonetheless he wants.
And I will produce that 2001 where the status of company has been status quo to be maintained for so far respecting the shares is concerned. I will maintain.
Sir, where is your case diary?
Case diary has already been submitted, madam. On the
Again, it was returned.
You had taken it back.
No, return করে original টা নিয়ে ইয়ে দিয়েছি।
Duplicate দিয়েছি।
Our claim is very. My lord, we just.
Yes, he has filed.
Sorry, on আপনার against.
না না আমার খুব ভালো মনে আছে।
Then
Mr. Roy Chaudhary only has to explain, my lord, in the CRAN we have faith that on 3rd of July 2024, where does Piyush Agarwal, the person who is the constituted attorney of Sparks, how did he assume a jurisdiction to affirm this affidavit before the Honorable High Court when the company is not in existence?
Case diary along with status report, madam. Status report up to that date, madam.
Which date?
Well, that kind of I can do.
Action. Sir, who will flag the case diary? Who will flag the case diary? It has not been flagged.
My lord, the affidavit of service. Service.
But the submission of learned advocates representing the petitioner, the opposite parties as well as the state. Next date be fixed on 18th of September for final hearing. 18th September we'll finish it off. Okay, sir?
Absolutely.
Acha. এবার FMA. What makes you smile so much?
Nothing, my lord. My coming and rushing to your lordship's court after a long time. After a long time, I received a message you have been called. So I ran.
Deeply obliged.
Deeply obliged. Deeply obliged.
For the respondent.
You followed the structure. Where's your other side, sir?
He was here. But
He
Sanjay.
was there.
Sanjay Paul. Must.
What is this?
Watering portion wala page 26.
163A. The paper book was it?
Landed tribunal wala whole notional income 3,000. But my prayer is my notional income is 5,000. This is the chart, madam. This is my chart.
Did you file any cross objection?
Yes, madam. File cause.
Yes, why have you filed the appeal?
First ground wallet that
This is of 2011.
yes, that driver of the offending vehicle was possessing learner's license. Kindly come to page 25.
So why have you come? Learner's license?
Page 25, the findings of the learned tribunal regarding driving license.
Which page?
Page 25 of the paper. The third paragraph regarding second objection. Page 25.
Yes.
Sentence start regarding second objection. Regarding second objection as raised by the learned counsel for the OP number 2, this court rejects the same and directs OP insurance company to pay compensation to be awarded by this court to the claimants who will get it reimbursed from the owner of the vehicle. Here, there is specific one, but ultimately in the order in question, there is no liberty granted.
This is your only issue?
No, another issue is there. Regarding notional income, although I have taken ground in the memo of appeal, but 2007 accident, 3,000 assessed notionally because no evidence adduced before the learned tribunal. 3,000, I'll leave it to lordship. Third point, regarding age. It was asserted that the age of the victim was 52 years at the time of accident. Now, two documents they have produced before the learned tribunal. That is that the page 59 is postmortem report. Page 59.
59.
Yes, my lord.
Yes.
Page 59, my lord, left-hand column top. Age Vishal Das, age 62 years. Again, my lord, can you come to page 68? Page 68. That is the death certificate issued by the hospital authority, my lord. Second line, you will find age 62 years. Bimal Das, next line, age 62 years.
Yes.
Yes, my lord. Learned tribunal, my lord, on the basis of oral evidence, my lord, held the age of the victim 52 years. And I applied, my lord, multiplied.
Where is the oral evidence? Which
Lord.
page?
Findings, my lord.
Oral evidence.
Oral evidence, my lord. That is at Shantanu Das at my lord, page 9.
Page 15.
Page 15.
14. Yes. Deceased Biman Das. Biman Das was my husband. I would married to Biman Das in the month of March 1980. At that point of time, I was 18 years and my husband was 25 years. Biman Das is no more alive. He was a cultivator and reason. No document to show that such and such.
Two documents, my lord, neither the Aadhaar card, neither the voter
That is,
card.
I could not place.
Nothing, my lord, no document, only
No,
death certificate.
no,
and
they're submitting the Xerox copy of the voter ID card.
that was not exhibited before the tribunal.
It says the voter ID card is marked as Exhibit 11.
But
in the
Page number 15, I also hand over the original totally. The voter ID card is marked as Exhibit 11.
Page 23, my lord. I do not, that is the list of exhibits, page 23. Page, voter identity card may be the claimants. Because my lord, here, my lord, death certificate and postmortem report of the deceased, thereafter voter identity card of the Shantanu Das and voter identity card of the Archana Das.
Who is Archana Das?
Archana Das is the my lord, Shantanu Das son, Archana Das my lord, wife.
Wife.
Na?
What is the age of Shantanu Das?
Age of Shantanu Das, that will reflect from the voter ID card. In fact, Shantanu Das adduced evidence.
Now in page number
61.
It says the age of the son was
87.
age was 87.
No,
He was born on 1st of February 1987.
87.
So this was marked as exhibit in the year 2011. So 24. 24. When did the accident occur?
In the year 2007.
2007. That means the son was 20 years of age in 2007.
Documentary evidence is postmortem report and death certificate.
52 would not be wrong. Where did the tell me the show me the observation of the tribunal
Regarding
wait
regarding age, I do not find any observation.
Page 23. Learned counsel did not dispute any age of the deceased.
Yes, what is the age mentioned in the postmortem report and death certificate? I have not disputed.
It was not disputed.
learned the age of this deceased to be as 52. From where did the tribunal get the age 52? From the claim application?
From the claim application.
$52.
Page 1, column 3. Age of the person dead 52.
The postmortem report and death certificate is exhibited.
Yes. What is your issue? Why have you filed the cross objection?
No documents is here, but
Why have you filed the cross objection? No documents are there.
Revision file because of enhancement of income, but there is no
only
regarding
notional income, only notional.
3,000 in the year 2011. It was good enough.
He was a mentions per day income was
that learners that and age.
No. Oh.
That learners the observation is page 25.
Page 36.
I leave it to us. I leave it. Only entire award that is being deposited before this honorable court, let them withdraw.
Peter.
So this cannot be dictated.
I am sorry, my lord.
You have only mentioned and thereafter it came up for orders. So you must have mentioned that you have filed a cross objection.
No, my
The
lord.
cross objection is not even appearing in the list.
Not place করে দিন না
Then, my lord, I am paying for not place this.
not placing cross objection.
List. What will he not press?
Let it be taken on this list much not. Well, let it be disposed of. Otherwise, well, again, the
Kindly
same
dispose
thing. And dispose of.
It cannot be.
I have filed the work.
When did you file? Hey, একবার চেক করে নিন। File. Maybe he is not aware. এটা খুঁজুক তাহলে ওরা যদি থাকে অন্যটা দেখছি ততক্ষণ।
Quad 12 or 2 quad 12 না না আমি বলছি কট নাম্বারটা বলছি না কট 12 or
নেক্সট
হ্যাঁ
What 12 are you?
My lord, I appear for the respondents. This matter
For the petitioner, Milords, as per the earlier order, Milords, I am submitting the written notes of arguments, Milords.
My lord, in this matter, my lord, the recruitment process was challenged. Only one post, Lower Division Clerk in Station Headquarters, Binaguri. Defense matter, my lord. Then, my lord, there was the process of selection. There was the board of officers. 3 board of officers were constituted. Then, my lord, the second board officer committed one mistake because he didn't consider the skill typing test. There should be the 75 words in 1 minute should be typed, and in 5 minutes it should be 175 words should be typed, and that was not taken care of. And that the in paper which was given to be typed, material which was given to be typed, those were only 160 words. And in the advertisement, it was the written test as well as the computer typing skill test. So in computer typing skill test, my lord, there should be 175 words in 5 minutes, when in paper 160 words were given. Ultimately, on the complaint of the petitioner, my lord, this was investigated and finally that was set aside, scrapped. That
entire process.
Entire process was scrapped, and it was said that you start afresh. But then, Lord, my learned friend filed this petition, and since then, Lord, no recruitment has taken place for that seat, Lord.
And you had shown, you had received a copy also of what you had typed?
Milords, what I have typed, I have received the copy.
That's what I'm asking.
Yes, Milords. And in that typed copy, there
Sir,
is 175 words.
Sir,
Milords.
in which, how many minutes you have done it?
Milords, that is in 5 minutes, Milords. Milords, this needs for an investigation. That's why this can number 2 has been filed, Milords. That this whole process needs to be investigation. What the Milords, what the authorities say, Milords, just a moment, Milords. Authorities say that they have not dictated the words of 175 words. But in my question paper, there is 175 words. So their statement that 175 words were not.
If the entire process had been scrapped, right?
Yes.
How are you prejudiced?
Milords,
I was an OBC candidate. That was my last attempt, my lords. Now, even if the
So you want the entire process to be revived?
my lords,
Uh,
the
I
question
mean,
of
isn't it fragmentary?
my lords, if the process was correct, my lords, if
They are saying the process was not correct.
Lords, on the basis
They had found out certain discrepancies.
that discrepancies,
They rectified it.
no, my lords, that is not
Just because you missed the bus, and moreover, I remember having seen that you were otherwise not
unsuccessful.
qualified.
In written test, he was unsuccessful. He was 5th in rank.
my lords,
There was only one post.
There was
only one.
Only one post. Only one post.
Then
my lords, I was not
why
fifth.
are you?
I was fourth, my lords. The three candidates, my lords, my point is, if I would have missed the bus, that means what the discrepancies they are telling, there was not 175 words, there were 160 words. Then I have missed the bus. But the question paper was of 175 words. Now the question arrives that whether I have typed 175 words in 5 minutes or not.
Not only that,
My lords,
whether you have typed those 175
in
words
5 minutes.
correctly or not.
Or whether I have typed
you
correctly
will-
or not, they have given me an RTI reply that what you have typed is the question paper.
You know, total words were 160.
True altogether. I mean, that it is a question paper means what?
That means I have
that
typed
was the
correctly.
That was the paragraph. No, question paper cannot be a correct answer. You cannot equate a question paper to a correct answer. If they had stated you in this words that whatever you had been supplied with had been the question paper, it implied that the paragraph which you had typed out was the question. Was the question, not the question per se, it was the dictated paragraph.
Dictated paragraph.
Right? So whether the words in the dictated paragraph was correctly typed by you or not was up to them to decide.
But they have not said
And
anything
Milord,
on
the
this point,
paragraph
Milots.
total
They have
160. Milord, the paragraph having the on total 160 words. Then how could my learned friend type
that is the
175
point.
words?
The paragraph was not 160 word, that was
That is there, Milord,
175 words.
on record.
Milots, their RTI
160
reply
words
says-
paragraph, total words. And they are claiming, my learned friend claiming that he typed 175 words.
Because the question paper, their RTI reply says your question paper is correct question answer sheet. It has 175 words. So they are saying this, not me, Milots. Now the question arrives.
So if you suppose you type out wrong words also, then suppose the
Look,
question paper or the for that matter the paragraph which was dictated to the
Suppose I have
concerned
typed whole
candidate.
thing wrong. I have typed a wrong answer.
So if you
Now,
type
Milots,
out a wrong
now, Milots,
paragraph, then also you
no,
claim
my
your
reply to
amendment.
this is Milots, the reply to my complaint, what they have replied, they said that Robin Bara, who was first qualified, he has completed the question paper. That's why he has qualified.
Completed the
question paper, and that's why, that is my point, Milots. If the question paper was wrong, Milots, he could not have qualified. Firstly, they reply me that the candidate who has qualified, he has answered correctly. Thereafter, when I complained, they said, no, we have found.
They found it. They
Yes,
found
investigated.
Out, they found out and they saw
Mistake.
That if they had given you a reply that yes, he was absolutely right, and if they had proceeded with that,
Milots,
then
they
your
proceeded with that,
grievance-
Milots.
No, they didn't.
No,
They
Milots,
didn't.
I will show you, Milots. They said what was their reply. They proceeded with it. They gave them that person a date of joining. He did not come to join. Thereafter, yes, Milots, I'll just Milots. Page number.
Investigation report is there, Milord. That investigation, it was investigated by a army officers and report has been filed. It was found that the second part has not been complied with because there were 175 words should be typed in 5 minutes. None of the candidate typed. Even in question paper, that the material given for typing, that material having the only 160 words. So it is there is a mistake in the conduct of the examination, and there is a warning also. Then why this second the officer, the board of officer committed this mistake? So scrape that and said that you start fresh recruitment process.
That has been stalled.
Yes, installed.
That was
That has
first
been
time
installed and
came on
it's scrapped.
record in 2025 when affidavit of opposition was submitted, Milords. Prior to that, what is the stand of respondent? May I just read it out, Milords? Page number 39 of my writ petition, Milords.
Sir,
just one line, Milords.
I
Just
am
one.
convinced.
Milords, just
I'm
for my.
absolutely convinced, sir. I am so sorry. Just because you have filed this written notes, otherwise I would have just dictated it today. I'll dictate the order tomorrow, sir. Tomorrow, if 3:30, no?
Milord, tomorrow, kindly excuse me. I
Okay.
will not be in town, Milord. Keep it on Monday.
Next. Milords, but just 1 minute, Milords.
Sir,
This
you
is a humble
also know
submission.
in the very
Nothing in the
core of
matter.
your heart, sir. You know it. Then why are you prolonging it?
Just I am trying my.
Your Lordship, keep it
Monday.
Monday. Good. Yes.
Milords.
Tried really tough, sir. Next.
Good.
এই রেকর্ডটা এখান থেকে ও মাঝে মাঝে কোথায় চলে যায় ও ওকে তাহলে এই কোর্টে কাজই করতে হবে না ও যদি
Actually, it's under section 163A. The learned tribunal awarded lordship 2,59,000. So I will take that advantage of the law. So you see 5 lakhs. So only this is the plea before your lordship 5 lakhs. So paper is not required. It's my according lordship fix the matter for forwarders.
So where's your application memo of appeal and all?
Yes.
এটার রেকর্ডটা কোথায়? Why did you file a supplementary affidavit?
Lordship, that is disposed of.
Disposed of. Why was it filed?
It was filed lordship attainment of majority in support of that. I have that is all disposed of on 13th March. Yes, 13 March 2025, lordship had disposed of the application.
এই পুরনো কেউ নেই ওরা কোথায়? টার্ন মানে অর্ডার 189.
Lord, this is an injury case, my lord.
Yes, Binoti Das,
Binoti
30%,
Das.
38%, not the
38%.
treating doctor.
Yes. My lord,
And
Lanet Tribunal completely disregarded the said certificate and the depositions, but ultimately Lanet Tribunal, my lord, assessed 25% functional disability. My lord, kindly come to page 26. That is the findings of the Lanet Tribunal, my lord.
96.
Page 26.
Yes.
My lord, during her cross-examination,
Huh.
the PW2 asserted to have examined the patient on such and such and admitted to have never rendered any treatment to her as she had faced the accident quite a long time prior to her examination. She admittedly observed in her certificate that as on 11/3/2020, the fracture injury sustained by the patient was healed up and except revealed union of bones. The witness averred to have never been attached to the facility where the instant claimant petitioner was treated. She admittedly did not advise any face X-ray to be done before issuance of her certificate and volunteered that same was not required. She acknowledged that the fact that in her report dated 11/13/17.
So without X-ray, she stated that the bones were reunited.
The previous
Which previous?
That was after accident. After accident, whatever Binodi Das clinically examined the patient on the basis of documents.
So she saw the patient to be mobile.
Not mobile, maybe. Anyway, the exhibit revealed union of bones. It was a fracture injury.
Fracture injury where? On the leg?
Leg.
Then?
Leg.
Hmm.
That in fact she acknowledged that fact that in her report that.
So the tribunal
completely disregarded the evidence of doctor and as well as the medical opinion given by her. But
so
ultimately,
to your favor.
Yes, but ultimately assessed 25% functional disability. 38%.
So this is what the evidence is that has been stated here.
Yes.
Then where is the opinion of the tribunal?
Page 34, third paragraph.
34, third. Finally, let us examine the extent of disability. As revealed from disability, certain the doctor had the appointed, but curiously, she examined him for 2 years from the date she admitted to have never rendered any sort of. The court cannot overlook the fact was a practicing advocate.
Let's. The doctor, my lord, assessed.
Wait. Yeah, it is well reasoned.
But at the 25%, completely disregarded with the evidence and the opinion, medical opinion, the tribunal suo moto assessed functional disability to the extent of 25%. Not that the tribunal upheld the deposition of the doctor and the medical opinion. Thereafter, applied his mind and assessed functional ability to the extent of 25%.
Okay, this is one.
This
Then
is one. Next, the assessment of income, Assessment of income. Can you come to page 34? Page 34 from top. Income tax returns March exhibit 24 says it surfaces up that the claimant petitioner earned income to the tune of rupees 2,74,669, rupees 3,27,900, rupees 1,67,980, and rupees 252 respectively during the assessment year 2018-19, 2019-20, 2021, 2020-21, and 21-22. It is evident that among the said 4 periods, her income soared most during the previous year, 2018-19, and most certainly it took a dip in the next financial year, in which she faced the case accident. As suggested by the learned advocate for the OP number 1, owner of that was year of COVID-19, and no doubt the financial potentiality of all business and professions had suffered a setback during this period, but there is no effective measure to quantify the effects of pandemic, and the intangible adverse impact of reduction in the mobility of the injured victim during this year on her income cannot be altogether ruled out. Be that as it may, the last full financial year in which the victim could work in a physically fit condition before the accident was 2018-19, and her net income for the said year as deposed by the concerned income tax employee was rupees 3,27,900. Kindly consider 2018-19, that 3,27,900. Now kindly come to the income tax return of 2018-19. That is at page 93. Page 93. You will find the annual income shown 2,75,464. That was no wrong recording. Tribunal held that in the year 2018-19, her income was 3,27,900, but in the document it shows that the income is lesser.
Acha.
2,75,000. I consider that the learned tribunal has just
This point is there. What else?
and regarding regarding finance happening also I have challenged, but I leave it to Lordship. The non-pecuniary damages I have challenged, I leave it to Lordship.
Alipurwani.
Locality. Yes. No.
The thing is there.
No, that was proof that in ITO officer was there. That was.
They are not challenging. They are only saying that after the date of accident and 2018-19, that was filed. That was the only income tax return which was filed before the date of accident. Malad will kindly. Date of accident is Malad
2nd August 2019.
2nd August 2019.
Yes.
Assessment year is financial year 17-18, previous to that year. Yes, Malad page 148.
Page 148.
Yes. This is the income that the tribunal has considered. Page 148. Malad kindly comes to page 148, middle portion, date of filing return. 31/8/2019. August 2019.
Yes.
2018, previous to that year. Malad kindly appreciates accident occurred on 2nd of August. She filed it on 31st of August. with regard to an income which concluded in the month of March 2019. 19. Yes. And 31st August 2019, they filed the income tax return. And my lord, what is the jump? 2,74,000 to 3,27,000 for the year ending 31st March 2019. She could not have perhaps inflated that, my lord. It is not a business. My lord, the accrual of income has stopped on 31st March 2019. No, subsequent income tax returns are also there. Yes. My lord, should I show the exhibited document? Yes. My lord, comes to page 165 is 2021.
So page
165, 165. Come down. Because this is the next financial year when she could not work and was hospitalized.
That was the pandemic period also.
Yes, that was also the pandemic period. So income went down from 3,27,000 to 1,67,000. After that also there's another income tax return. My lord, kindly comes to page 177.
170.
This is assessment year 2021, 2022. Sorry, I'm sorry, my lord. Page
178.
It starts from 175.
178. You will find that 178.
Yes, 2,41,000. It has again increased a bit.
Income was gradually increasing. That in. But Malad Lanet Tribunal Malad upheld the income tax return pertaining to assessment year 2018-19. 18-19 shows the income Malad is
Yes. August 2019. 2nd August 2019. Within the same month. 2nd August, 31st August.
Malad kindly consider the findings of the Lanet Tribunal. Malad where it is Malad the Lanet Tribunal assessed Malad the income considering the assessment year 2018-19. 18-19 shows the income 2,75,464.
Malad, may I say something? What has happened here is we are considering assessment year 1920. That is his objection. The place where Mr. Paul is mentioning, it does not mention financial year or assessment year. It only mention accident was 2018 and 19. So it does not mention financial year or assessment year. There lies the confusion.
Because income tax return filed considering the assessment year, not financial year, because all the document filed when considering assessment year.
To 3,27,000.
3,27,000.
Malad, may I just Malad, Malad will kindly have this is the latest Supreme Court, April 2025. Malad will kindly consider paragraph 12. This will settle the issue. Paragraph 12, my lord. Just because on the date of accidents, that is such and such, the return for assessment year such and such had not been filed, my lord. My lord.
Page 8.
Lord, this was of 22nd April, my lord. So, my lord, in any case, yes, yes. Well, don't have any cross objection, my lord. So, whatever the tribunal has awarded. Yes. So, Well, actually, when the income tax return was filed, she was hospitalized. It was the last date. That's why it was filed on 31st.
No, no, you have deposited the entire sum. So remove. Next.
But 190 was insurance appeal. My lord was kind enough to take up this matter yesterday, my lord, due to paucity of time, my lord, the order could not be passed.
Hmm.
My lord, it's a death case. One 47-year-old man, my lord, while riding a motorcycle, my lord, he was hit by a Maruti van, and my lord, and he died. My lord, the compensation of rupees 29,49,929 in principle with interest was passed. I have deposited the entire compensation amount before my lord's court with interest. My lord, the main point of appeal, my lord, the ground what I had taken, my lord, was non-involvement because of the delayed lodging of FIR of
29 days or something.
43 days. 43 days, my lord. It was shown to your lordship, my lord, at page number 19 and my lord, 21 yesterday. Your lordship is kind enough, my lord, to come to 21, my lord, the written complaint.
FIR is in page
FIR,
number 19.
FIR is 19, my lord. It is to show your lordship, my lord, that the item column number 3, my lord, that 3C, accident on, my lord.
Accident was on 22nd of
July
2016, and it was filed on
15th of August.
15th of August.
That is
And Mr.
Milord Mondal had shown Milord
Mondal
yesterday, Milord, the reason that why it was delayed,
that,
that was at page number 21, Milord. The first paragraph, the very last two lines. Page 21. So, my lord, this, my lord, was yesterday of the view that this explains the delay of 43 days. Although, my lord, I had tried to show your lordship, my lord, that the distance between the police station and the victim's residence was only of, my lord, 5 minutes. And the eyewitness, my lord, had stated that he knew the victim. In spite of knowing the victim, in spite of taking the victim to the hospital, he chose not to inform the police, not to inform the, my lord, the family, and my lord, none took any step, my lord, to inform the police.
I will state your submissions.
Lordship, and Lord, as far as Lord, the quantum was concerned, Lord, I had taken the plea that the victim, the widow stated, Lord, and admitted that victim used to deal with Lord hiring of vehicle business. Lord, income tax return
managerial issue.
Managerial issue, but Lord, since it has, I have not brought in any witness, and Lord, it is not very specific. It is not absolutely sure also whether what kind of business.
You have mentioned about that house property.
Lord, house property also, but Lord, I have 8,000 or
8,600.
But it is so, Lord.
In any case, my lord, it is wrong because there's no, the income tax return does not reveal any house.
Lord, it speaks about other business.
So if it is not there, why do we get
So I would not be stressing on those. Lord, the income tax return is there, which was filed prior to the death of the deceased. So, Lord, that is to be considered. Lord, the award has been satisfied. I mean, it has been.
Now, what did the tribunal consider?
Tribunal, Lord, discarded
which income tax return?
The one filed prior to the death of the deceased, my lord, immediately prior to the death of the deceased, my lord.
I do not have any cross objection.
Okay. So while I dictate, you just give me those pages as and when I ask you.
My lord, 192, my lord, is Clement's appeal. Mr. Roy is there. My lord, your lordship had heard this matter earlier, and your lordship asked us, my lord, to make the calculation. My lord, we have made the calculation. It's a death case, my lord. An employee of ECL, 44-year-old man, award of 44 lakhs was passed. There was error of calculation, and future prospect note was wrongly given at 2 places. Net income was not considered in view of income tax return. We had seen that. We have made the calculation.
So you tell me the pages and the
Lordship,
exhibits.
lordship.
39, Lordship, kindly see the page 39. That is the
Page 39.
page 39 of the paper book.
Now, what are your submissions? You tell
That
me.
is my submission that the learned tribunal ought to have considered the certificate issued by the employer under section 203 of the Income Tax Act. That certificate not considered by the learned tribunal properly on
Which page?
page 39 of the paper book.
Wait. What is page 38?
Page 30 of the income 39.
No, page 38 is what?
No, page 39.
I'm asking you what is page 38?
Page 38 is the lordship income returns.
So page 39 is the continuation.
Yes, page 39 is the certificate under section 203 of the Income Tax Act.
My lord, page
Now,
30,
page
page
38.
38 is the my lord self-declared return filed by the victim, and my lord, page 39 is the my lord department's assessment, the final audit.
So both of it tallies?
Just a little difference is there, my lord. That is why, my lord, what department has said, we are going by that. That's what my lord's view was. Your lordship will kindly come to page number 39.
Now the self-declaration, as you're saying, it's 556452.
Yes.
And now what did the department find out?
It is 551730.
Your lordship at the left, number 1.
Yes, 551730. Now
Lordship.
what did the tribunal consider? The
I also kindly see from this page the deduction tax TDS and deduction 15890. The lordship kindly say just next column, bottom lordship kindly see the list column number 17.
Column number 17.
17. 15890.
From where is it? Column number 17.
Not in the middle.
Okay.
In the middle.
15890.
Yes, that figure also appearing from the page 38, 15890.
So this has been deducted.
This, my lord, the income is to be considered as number 1, 551730, and this, my lord, number 17 is the tax which is to be deducted from the gross income. So, my lord, net income comes to 535840. We have made calculation before your lordship.
That's what I'm saying, that this amount has to be deducted.
My lord, my lord. Yes.
So this is your only issue.
And lordship, the future prospect not considered by the land.
Now tell me, despite these documents, what did the tribunal assess?
Lordship, tribunal assess the average income.
Average income of?
Average income of the victim. Lordship,
So this was just prior to the death. Income tax return was filed.
the date was there. Yes.
Date is
Date, lordship, I'm supplying the date, lordship, plus 39.
11th of August 2016.
And he died on 15th of October 2016.
And
October 16 is the death.
Okay.
And August 16 is the accident.
And also certificates of 2003, 203 also 38th June 2016.
My lord, your lordship wanted.
That is the assessment made by the department.
Lordship.
Where 551730 comes. So that is, where is that date?
Date, lordship, kindly say just second column last, dated 38th June 2016.
But then what is this? 2nd of August 2016?
Lordship, kindly
There is a
see here.
signature finance manager.
Yes, just left hand, lordship, kindly see the date. And lordship, it is also period. Lordship, will get the first column period 1st April 2000.
Period from 2015 till 31st of March 2016. Assessment year is given.
Yes.
Now, from where did you get that date that you've just stated? It says somebody has signed this in the middle portion.
Yes.
Just below.
Just below.
Now it is dated 30th of June 2016.
Yes.
Oh, somebody else had signed it on.
Signed and certified.
Okay. Okay, this is the issue.
This is the issue. And the future prospect.
Now, future first. Now tell me, you had to show me where the tribunal has
Page 58, last paragraph.
58.
58, last paragraph, Milord.
Is 59 lawsuit the future prospect?
এক সেকেন্ড দাঁড়াও আস্তে আস্তে বলতে দাও।
58
Milord 58, first paragraph, last sentence. Exhibit 14, salary slip
shows as a salary of the
of the
deceased.
victim was 412,555. Milord, the salary slip, Milord, the net salary was taken into consideration. Certain deductions were taken off. Which
No,
were,
where is that 14
Lordship,
exhibit?
Milord, I'm bringing to your Lordship. Milord, subsequent to that, your Lordship will kindly also go to the last paragraph.
As per document salary slipping
Lordship.
such and such in a year after
And this is
deducting.
corporate.
No, that to calculation has been done.
Lordship, Milord,
You
this is
show
why I say the
exhibit-
difference.
Okay,
Lordship.
you show me the
Salary.
exhibit 14 salary.
Exhibit 14, page 34. Hold it.
No, from where did that amount come? It is not reflected here.
Here, Lordship kindly comes to October 15 to September 16, that 12-month salary statement is there. But Learned Tribunal come to an average.
No, if you add these, what is the total amount? Same as it is reflected in the IT?
No, no. Because Milord, this herein, Learned Tribunal just said that it is 414, Milord. That is what.
12,555.
So that is the total amount of this 41060408006 like that.
As per
41,000, 40,000, 42,000,
Yes,
49,000.
Lordship, kindly come to the page 58, last paragraph, first line. As per document salary slip, income the deceased was 412,555 in a year.
So in this you have added this allowances.
All the allowances in the net income actually considered, not gross income considered. So accordingly, after summation of the entire 12-month salary, that figure will come. That is the observation of the Learned Tribunal. But my humble submission, the Learned Tribunal ought to have considered the page 39. There the authority has issued the income tax.
Milord, in any event, the total of this page 34 would be, Milord, is approximately 5 lakhs because it is more than 40,000 each month. 40,000 into 12 is 4,80,000.
Along with this. So it will, in a way, it will coincide with the amount that has been reflected in the
And there were
income tax
certain areas also which were in Milord subsequent pages at page 36. So those are also to be considered for the same year. So that is why Milord, income tax return, Milord, is the more reliable document. We go by that. And Milord, we have given the calculation to your Lordship, Milord. The enhancement is shown.
This, you mean to say the special allowance?
Lordship,
All these things in page 36. Nonetheless, if it is more or less equivalent to that of the income tax return, the figures that are reflected in the income tax return.
Future perspective.
Future prospect, Learned
Lordship, this is insurance company's appeal, Lordship. Lordship, on 24th August 2012, when the injured, the claimant was traveling in a Tata Sumo, a private bus hit him, and as a result, he sustained several injuries. This is an injury case, Lordship. And learned tribunal has granted sum of rupees 3,67,000 along with interest to be payable. The awarded amount is already deposited before this honorable court, Lordship.
5,30,000
না ওটা ইন্টারেস্ট নিয়ে হয়েছে
না না না
interest was paid total
6.5%.
total was paid. Because of the ground, Lordship, in this case, Lordship, what has stated that on 24th of August 2012, Lordship, the accident took place. He was taken to a doctor before Basudev Mondal, and he has given the first aid, and thereafter he was released. After 13 days, he stated that he was hospitalized in National Medical College. When he was hospitalized, the diagnosis was prognosis. There was not written that he was any shoulder or any the fracture. What is they have claimed that there is a fracture in the shoulder and there was plate was inflicted upon. That was not written. Thereafter treatment was done and he was released. I have come over here that if a person sustained any fracture, then initially he was first aid and there was he was released. After 13 days, Lordship, and when he was admitted to the hospital, there was no reflection of that, Lordship. Kindly comes to page 37. Kindly comes to, first of all, page. Yes, Lordship.
There is no evidence.
No evidence was there.
PW1 page 9 to 9 to
PW1 page 9,
9
page
to
9, 10. 10 is the examination in chief. Paragraph 3. Yes, Lordship. First of all, I am referring that, thereafter I will give. Examination page, paragraph 3, Lordship. I was inside the Tata Sumo along with others. As a result, I sustained several multiple injuries and initially treated under Dr. Basudev Mondal. I got admitted in Calcutta Medical College and Hospital on 5/9/12. I had a fracture on my right shoulder and operated on 7/9/12 in the said hospital and discharged on 22nd/9/12. And since he was given first aid, that is mentioned in the judgment, Lordship. Kindly comes to the page 23, Lordship, of the judgment. I was OP2. Yes, Lordship. OP1 is the insurer owner. Lordship, kindly comes to page 23. I was reading page number 10, Lordship. Internal page 17, page number 10, PW1, paragraph 3. Filed. And like, yes, Lordship. Lordship, the cross-examination, I was filing the, I'm reading, I have filed examination chief. Page 15 is the cross-examination in chief. Page, bottom of the page. In my PAN card and voter ID card, my name is mentioned, such and such was not identical. Lordship,
no, nothing.
Judgment, Lordship, page 23.
Nothing.
No, Lordship, that exactly that point of first aid was not taken in the cross-examination, that I admit. But in the kindly comes to the page 23, the judgment of the Honorable Court, Lordship. Reimbursement of medical bills, Lordship. From the evidence of PW1, it will appear that injured was initially taken to Calcutta National Medical College and Hospital. He received first aid and released, and later he was again admitted in the hospital on 5/9/2012. He was ultimately discharged on 22nd/9/2012, Lordship. And the document was first when was taken to before the doctor. That is page 38, Lordship. This is one point, Lordship, and the disability certificate, Lordship, is not properly issued. That is page 53. The PW2 is the doctor who issued the disability. 55, Lordship. The treated doctor was not examined. PW2 is the doctor who has issued the disability certificate. Page 17 is his deposition and the disability certificate, page 55, Lordship. There is in the cross examination she has stated in page 17, Lordship, without there is no history of the road traffic accident related
25%.
25%, Lordship, and there is no mention that he was without any employment for 6 months. There is nowhere mentioned, but the learned tribunal has considered that there is a loss of income for 6 months, Lordship. There is nowhere mentioned, even the PW1 did not stated that. This is one point, Lordship, and my another point is disability certificate not properly issued. The treating doctor was never examined. The disability certificate was issued after 2 years, and that too without examining the patient. Only on the basis of the documents it was issued, and not as per by any disability by any medical board or anything, Lordship. And another point is, Lordship, there is he was a salesman. He has not filed any document
My lord, that is about 17 days.
on 5th
My
of
lord, your lordship
September he was admitted, and
My lord,
22nd of 5th of September he was admitted. On 22nd he was released, Lordship.
my lord, he was operated in the right shoulder, skull was injured, skull of the shoulder was operated, and he was admitted on the date of accident. And my lord, thereafter, your lordship kindly turn to বলা শেষ হয়েছে
Lordship, the income is also it is a case of 2012. He was a salesman of a grocery shop, but no supporting documents or anything else was given. The notional income was considered at 5,278, Lordship. And Lordship, for pay. And Lordship, one more point is the interest 6.5 was considered, Lordship. And 2 vehicles were income fault. Only 1 vehicle, this purported vehicle, was considered, Lordship.
Yes, my lord, these are the 3 grounds.
Did you file cross objection?
No.
Acha, tell me.
My lord, these are 3 points, my lord, taken my friend. Composite negligence because 2 vehicles are collided, but the charge sheet, my lord, filed against the the driver of the bus. So it is my lord, offending vehicle is the bus. My lord, here the victim injured was traveling in a Tata Sumo. 3% died and my lord, 2% injured. Out of 2% injured, my lord, one is Sajan Mullah, my client. My lord, it appears from the charge sheet that after the accident, he was, my lord, shifted to the National Medical College. Thereafter, my lord, he released, and my lord, after that, my lord, he was admitted in the National Medical College, and he was admitted and remained 17 days. In 17 days, he was operated in the right shoulder because right shoulder skull
Yes, plate was implanted.
implanted.
Then
So 25% disability, my lord, as the doctor Minoti Das, my lord, says, my lord, they are not, my lord, they are not producing or adducing any evidence contrary the evidence of a Binuti Das, who is a orthopedic, my lord, orthopedic surgeon. His certificate has been accepted by the tribunal. Now, my lord, second point is income. Income, my lord, accident took place in the year 2012. So, my lord, as per the minimum, my lord, relying on the tribunal justice versus so and so, my lord, your lordship has seen, my lord, many cases Supreme Court says, but there is no, my lord, the evidentiary income, my lord, proof the minimum wages. My lord, here the minimum wages 203 per day. On the basis of 203, it comes, my lord, 500. On the basis of 5,000 something, learned tribunal assess, my lord, and multiply and 25% future prospect, and this is the, my lord, the assessment. Nothing else. My lord, composite negligence gone.
my lord, the doctors, my lord, evidence, my lord, because since my lord, there is no contradictory evidence, so my lord, the evidence from our end cannot be shuttered down, my lord, because there is something, my lord, and also the law says if a qualified medical, Rajesh and Rajkumar also says qualified medical practitioners give certificate, that can be treated as a loss of income. So, my lord, the 25% disability is not much more, my lord, that, my lord, that should be reduced. So, the 25% on the basis of 25% disability, land tribunal assess, income is 5,000 something, future prospect, and pain and suffering, 1 lakh has, these are the assistance.
What was the total amount given?
So 5 lakh, 30,000.
5,30,680.
In future, my lord, he was aged about, my lord. He was
There is no evidence of future
25
treatment.
years, rest of life, my lord. Even if, my lord, in evidence from PW, he says he felt weakness and he cannot do his even the work, my lord. He was a, my lord, even if unskilled laborer, my lord, he was not doing the, my lord, the job which he was doing, my lord, before the accident. That evidence, and that was not, my lord, contradictory or rebutted.
No document or evidence of future treatment. No document or evidence produced for future treatment.
So that was not granted. That was granted?
No, that was
That
not
was
granted.
there. Lordship, may I place a written submission?
But
Yes, sir.
I have the reference, I don't have a copy of it now. Vibhor Fialo, which Mr. Singh had referred to. Vibhor.
yes, kindly dispose of the matter. 20% is not. I'm grateful to. But yes, yes, page 28.
Page 28 in the advice for operated. Lordship has considered the monthly income as 5,278. Lordship.
Yes.
They have not
Plus
to prove that.
plus
Lordship.
future prospects.
That was
Plus and valid visibility.
25%. ওই জাজমেন্ট অনুযায়ী করেছেন।
And paid and safari 1,000.
1 lakh,
1 lakh.
Yes.
My lord, it's an insurance appeal. Lordship may kindly come to our grounds of appeal in page 30 of the paper book. There is only page 30, my lord. Page 30 of the paper book. Yes.
My lord, I am for the claimant.
Mr. Mondal was there, my lord. Now he is representing. Page 30, there, first point we have taken, no disability certificate, my lord. Page 30 of the paper book. There, my lord, we have taken 4. Main point is 4. Not disability certificate, then no disability certificate. Then, my lord, also they have granted 3 lakhs instead of 1. This the tribunal cannot
Pain and suffering was
and also,
not
my
to be
lord, the
granted.
income has not been proved. Income they have taken 6,000 as a housewife, and then, my lord,
Accident occurred in which year?
accident occurred in accident about
2016.
2016, my lord. 14/1/2016, around 3 p.m. 14 January 2016.
Okay, so your first point is disability.
No disability certificate. Lordship may kindly come to page 21, the observation of the landed tribunal.
Page 21.
Yes, page 21. In the bottom, as there is total absence of disability certificate in this record, the tribunal cannot conclude that the victim has suffered any permanent disability due to the said accident. In view of the above, the point of number 4 is answered as unsettled and against the claimant. So it is the observation of the learned tribunal. And, my lord, as far as the medical bill also, my lord, I am also referring the cross objection of page of PW1, page 14-15 of the paper book.
Yes.
Cross-examination in bottom. It is fact that there is no seal and signature of any doctor or issuing officer of Peerless Hospital Research Center learned on any page of the final bills produced by me. The names of the person who have prepared and issued the day-to-day bills are not mentioned in the said documents. Volunteers, there is name of the person who has issued the final bill statement in its page. His signature is not there in the last page of the final bill statement. Then, my lord, it is fact that there is no signature as the receiving officer or cashier on the final bill statement to prove that the said bill amounts to have received. Then, my lord, there is no signature of Dr. Sudipta Mukherjee under whom the patient was admitted in the said bill statement. It is fact that there is no signature of Gautam Roy Chaudhary, who is purported to have prepared the final bill statement. That is there, my lord. Everything, because lordship knows it is a.
Sir, this he is the administrative officer
Yes.
of the hospital.
Yes. My lord, this is the whole short. In short, my lord, I am submitting. This is the whole thing. Insurance companies, of course, is a benevolent legislature, ready to pay.
Sir, what about this? I have been authorized to appear before the court along with the attested copies of the better tickets, bills, admission consent form, prescriptions, treatment sheets, and final bill statements in respect of the patient, Mrs. Such and Such, who was admitted at a hospital on such and doctor, under doctor
Lordship.
such and was discharged on such and such. Was there for
14 days.
14 days.
Malad, may I say something, Malad?
finish
Malad, I'm sorry.
one issue, and then
Then, my lord, these are the things what we have, nothing and nothing more than that.
so you mean to say now where did the tribunal err?
Tribunal has heard page 16 onwards, 17, the written statement.
Compensate, what is this? Medical treatment, pain and suffering, loss of amenities of life.
Tribunal has observed, my lord, rash and negligent driving is there. It's all right.
No, medical treatment is there. Pain and sufferings, 3 lakhs.
Malad, since
Not-
disability certificate, it is an admitted position, we could not produce. So loss of earning capacity cannot be assessed. So Malad, tribunal has rightly, I do not have any cross objection. I am only defending it to the extent of 8,90,000. Malad, tribunal has given only non-pecuniary damages of 6 lakh rupees and 3,65,000 rupees is my bill. If my lord kindly comes to page 26, this is the for medical treatment 3,65,900. This is I have proved through these documents the final bills. Pain and suffering, loss of amenities of life, transportation cost, food and nourishment, and future treatment. This is entirely non-pecuniary damages, 6 lakhs. Now, my lord, Mr. Chakraborty's point is that how can 6 lakhs be awarded in a case where the damages has disability has not been assessed? In this case, my lord, I have only one document to rely on, that is at page 19. এটা একদম লাস্টে চলে গেছে মানে it's at the end of the this is the hospital peerless hospitals bill. কোথায় আছে কত পেজ এইটা এইটা পেপার বুক হ্যাঁ পেপার বুক
Was it marked as exhibit?
yes বলো এক্সিবিট বলো has my lord
Discharge certificate.
well this is the final bill at page 19 it is mentioned 19 my lord is at page 29
17 to 30 বলছে তো part 2 paper book.
Yes. If my lord kindly comes to the discharge certificate at page 29, last but one page, page 29, last but one page. Kindly see, my lord, the predicament of the victim. Final diagnosis: post-traumatic left femur shaft fracture with intact neurovascular status, post-traumatic maxillar fracture, post-traumatic mandible fracture, triangular fracture anteriorly, left zygomatic complex fracture, deranged occlusion left eye with tightly sutured lacerations around left eye, minimal pleural effusion. History: this 47-year-old lady complains of pain in left thigh and face after an alleged history of RTO on such and such at around 3 p.m. associated with profuse bleeding from nose. No history of LOC vomitings. Patient was initially managed outside where lacerated injury around left eye were sutured and nasal packing done. Patient referred here for further management. Patient unable to stand and walk. My lord, kindly once takes page 19.
I've seen it.
This is the final bill. My lord, severe injury on the face. I do not know, my lord, frankly speaking, why the disability certificate was not produced before the tribunal. But my lord, 6 lakhs rupees for this kind of a injury, hospitalization for 14 days. My lord, out of this 6 lakhs non-pecuniary damages, my lord, I humbly pray, my lord, will not interfere with this. It is true that they could not produce.
Indication of the bill, my lord, lordship.
So you have deposited the
Yes,
entire.
entire amount we have deposited, my lord, and balance কিছু থাকছে?
No, no. Along with interest, my lord, we will
6%?
6%.
And income has not been proved, my lord. Income also not been proved.
Let's not get into that.
No.
If they could have produced the disablement certificate, sir, the compensation would have
18 screws
the
in her face.
I mean, the compensation would have enhanced.
My lord, more than disability, she faced disfiguration. In the disability
So I
code,
said deformities.
Yes.
I said deformities.
My lord has said.
What thing?
25% for 1/4, that is 6.25%.
Is it-
Other
Next one.
একটু দেখিয়ে দেবো কাইন্ডলি স্টিক বলে এরকম হবে
I will check it up, sir. I will check it up. Next. Indescribable.
Mr. Sanjay Pal, my lord.
Where is Mr. Sanjay Pal? Went home.
Has left.
And who all are present then?
For the insurance company, only Mrs. Gopadas Mukherjee is here.
Yes, what about 199? She has also left. Shima Ghosh?
Yes, she has left.
She has left. 200, Mr. Rajesh Singh has also left.
He has left.
Yes, my lord, he is engaged in another matter, my lord.
He is engaged in another matter.
Yes, my lord.
Okay. What about 204?
Yes.
Both sides are same.
204, 205. Yes. Tell me.
File and cross application.
If the Lordship kindly takes up the judgment of the learned tribunal at page 53, my lord. Page 53 of the paper book, my lord.
Page 53.
My lord. I'll be referring to the relevant page as page 58. my lord.
Page 50?
58. My lord, the chart where the calculator has been made out by the learned tribunal, my lord. The chart where the calculation has been made out by the learned tribunal, my lord.
Monthly income cross.
My lord, it has taken 1 lakh rupees as annual income. My lord, I'll come to that later on, my lord. First is monthly, second future prospect, third annual income, your lordship will find 1 lakh. Then deduction 1/5 of annual income. My lord, there were 5 dependents. 1/5 could have been applied had there been more than 6. Had there been more than 6, 1/5 could have been applied.
So this is correct.
No, my lord, there were 5 dependents.
5 dependents.
So this is incorrect. That would be this would have been 1/4.
1/4.
How many?
5.
5.
Okay.
4 to 6, my lord, 1/4. So Sarala Burma is applied, but the application is wrong.
So instead of 1/4, 1/5 was taken.
Yes, my lord. That's my first
That's
point.
one.
And second point is the 1 lakh income. My lord, your lordship will kindly come to page 57, the page prior thereto.
Yes.
The third paragraph. In this case, it is stated that the petition that the monthly income of the deceased was such and such. It is evident from the evidence of PW1 that her husband deceased dealt with betel leaf at Maniktola and her husband used to run his business on a rented shop. Though she did not say the address of the rented shop, in this case, the claimants have filed their 4 income tax returns, assessment year 2012-13, 13-14, 14-15.
When did the accident take place?
2017.
2017. 17. Okay.
17.
And my lord, relevant parties, my lord,
The tribunal considered the last income tax return.
No.
My lord, let me
No.
No, my lord.
Let him finish. Let him finish thereafter.
The last
I have a
return of
cross
the assessment year of 2015-16 was filed on such and such, and the later dated such and such shows that the process had not been completed. The claimants did not file any document to show that the process in respect of the above mentioned assessment was been completed. So we cannot consider these documents to determine the annual income of the deceased. Malad, the learned tribunal did not consider the relevant income tax return, and Malad took 1 lakh rupees as annual income without any justification. Malad.
Okay, so 1 lakh and this 1/4.
Malad. Now, Malad, they
1/5.
have 1/5.
1/5.
Malad, they have
And
filed
what
a
else?
cross objection, Malad, with a point that they have filed income tax return and they want to enhance the income.
I have a cross appeal.
Cross appeal. They want to enhance the income.
No, you show me that last income tax return.
Yes, ma'am. It is at page 142.
No, it was filed on
Yes, just a second. 42.
31st March
31st
2016.
March 2016.
31st
That
March
is to be considered.
2016.
That is to be considered.
Now,
Accident takes place on, my lord, 20th January 2017.
28 January 2017.
17. This is to be considered. Bound to be enhanced.
no, but from here 275 will be deducted. Tax payment 280 will be deducted.
280.
Tax payable
280 will be deducted. 280 will be deducted only.
So why this was not considered?
Well, because learned tribunal held that they have not produced any document to show that this TDR was verified. Well, it was processed.
This was not marked as exhibit?
Yes, this was
marked
marked as
an
exhibit.
Who came to prove this? I mean, who had come to
Well,
depose-
this was proved on behalf of the claimants, but my lord, your lordship kindly takes a page 47. My lord.
No, but then nobody came from the income tax department.
Not on their behalf.
Page
47. This was a document that was produced on behalf of the insurance company because the last income tax return which they produced was invalid by the department. Your lordship will find the last one. It was filed after death of the victim by the. So this was produced by the insurance company. But so far the claimants have concerned, they have not produced any document to show that the income tax returns were processed. And apart from that, my lord, I just place one judgment. Kindly consider this one.
Judgment.
Well, they run a, the victim run a business of betel leaf. No document in respect of the business, or in fact, the address of the shop was also not disclosed. Now, only this income tax return they are relying upon in the cross objection to increase their income. Though it's
that
not in
too,
a
it
claim
was
case,
not. I mean, none appeared from the income tax department
no, it was not corroborated.
to authenticate it.
Normally.
So it was their document.
Yes. Malad, only just I want to place this.
If you want,
Which one, my lord? And your lordship can come to page 47 once. Who has signed this document? Page 47. What is that? Is the document of the address to the division? Yes, my lord.
This was produced by the insurance company.
Produced. No. That so far 16-17. I am not questioning 16-17. I am playing only for 15-16. You also can remand it in that effect.
Only then, Malad, kindly don't consider this judgment. No, Malad. Let it be stored.
But may I hand over one judgment to that effect? Latest judgment, income tax return to be taken care of by the insurance. Yeah. As your lordship.
Where 206, Mrs.
Not today, Lordship. Mrs. Paul is appearing for the appellant. I'm for the respondent.
207. Yes, tell me.
207.
207. Why have you filed?
No, only short point in
What short point?
Short point is that my lord, pay and recovery, my lord.
Huh?
Pay and recovery, my lord.
Pay and recovery.
Yes, root. There
There was no route permit.
Yes, my lord. Exhibit 11, my lord, page 51.
Exhibit 11. Page, it is
51. 51. Yes, my lord.
Pay and recovery, page 51. Yes, what is it?
Conditional route permit were allowed, but that condition has not been fulfilled. That is why, my lord, your lordship kindly see the footnote, my lord, that renewed up to 17/9/2019, subject to replacement of the vehicle WB 25B.
When did the accident occur?
Accident occurred, my lord, 5th June 2019. 5th June 2019. 5/6/2019.
So what?
In the meantime, actually, conditional
What are you
route permit
saying?
was granted.
Nothing doing.
No, conditional route permit was allowed. That, but 19.
Permissible one within 16/5/2019.
19. But that has been replaced within 16/19/2000. Yes, my lord.
In this present case also, as usual, admitted position is that no 170 is filed before the owner travel. Did not obtain any permission under section 170 before the owner travel insurance company.
Exhibit 11. My lord.
So Singh is still
Yes.
occupied somewhere?
Yes.
Which court?
Hmm.
He is in front. He coming ahead.
He is in a commission, my lord, taking evidence. If the evidence is being taken of a person, so he is engaged there, my lord.
In a commission, not before any court. What are you?
My lord.
Then you said he is in a court?
I
He's
said
before a court?
he is engaged.
Anyway, I don't want to get into debate with
I,
you
I,
now.
I,
Mr. Singh is not there. So, 212, you are there?
yes.
And who is your other side?
Mr. Pal.
He is also left. So then,
Two can be taken up, but other matter are.
you and Mr. Mondol, both of you are there in any matter?
Yes, I am with Mr. Upadas Mukherjee.
You are there with Mr. Gopadas Mukherjee. Which matter? Huh?
232.
232. Yes. It's your good fortune that Mrs. Gopadas Gupta, what is her? She's there till 5:30, nearly 5:30.
Under the impression tomorrow she will not come. That's why
He knows better. He knows better.
Because you know each other better for years. So,
He knows better whether I come tomorrow or not.
acha record ta dekhi. So this will be the last one.
This will be the last one. This one.
The appeal under section 163A minor, and there was, I have made an application number 3 about the that was also value of the appeal was typed wrongly, my lord.
That has been allowed.
That has been allowed on the last occasion, and my only point of point in coming is the appeal is, my lord, invalid driving license free and recovered. That was taken in the written statement also, and a report was also placed before the learned tribunal.
If you go into all these,
No, there is no evidence. There is no evidence. There is no evidence. So, Lordship, only please that last year disposal of the tribunal awarded 2,54,800. So 5 lakhs.
I'm grateful, deeply obliged.
Two
232 and 233. আমি নিজেই তো পাবো।
So today we disposed of 9 matters.
নয় করে চলছে।
532.
নয় করে চলে যাচ্ছে।
532
হ্যাঁ?
already.
নয় করে চলে যাচ্ছে।
9 করে।
আগে কোন হচ্ছে? আগে
Yesterday was
that is why lordship by that time lordship will part her then to interview remains will remain. You are so sober, lordship. That's no, silent, sober, অল্প কথা বলি একদম ভালো থাকে।
আর কত নিজের বলবি?
no. You see, the bulk gets transferred, no? So at that point of time,